meant to start with a civil application, but due to discussions in chambers, it was decided that it might be better to deal with the pre-trial matter before. So hence my robes and hence the pre-trial appearances haven't been full. Sorry, you are for number?
I'm for number 2 and number 12. However, I'm going to withdraw with the legal record for case number 2. I'm informed that he has terminated the mandate of my instructor.
And is this for the record your name?
M.S. Mazibuko from the local bar.
Thank you. So 2 and 14.
And 12.
2 and 12. Have you got that easel? 2 and 12, and you now want to withdraw for accused number 2.
For number 2.
All right. Well, I take it he's present.
He is present, and I'm informed Mr. Samkele will be appearing on his behalf.
All right. Where are the accused seated? Because we're now dealing with the pre-trial. Where are the accused? Simply not going to help us. They're going to have to... are all the accused here, gentlemen and ladies? Are all the accused present? Number 1?
Yes,
Mr.
number 1 is
McKinsey?
present, madam.
Okay. Number 2? I wonder if you can't just get to a point where you're together so that I can see. So number 1 and 2 are here. Number 3, Mr. Soli, are you there? And of course number 4, number 5. Who's representing?
So, my lady, I explained the
yes,
position
you
number 5 to you.
Mr. Jagna.
That's great, my lady.
And you said that the representative of number 5 is not present
It's
due
not
to
present
medical
to
issues.
foreign ill. Our doctor's note will be furnished.
But you
in
are
due course.
present for number 5, and then number 6 was, I think, Mr. Hodes, you said you're standing in.
I was
for.
also standing for number 6.
Who is the, and is number 6 here?
My lady, there must be a representative of accused number 6. Accused number 6 is a
Yes.
company, but Michelle Mpambani.
So is the representative of accused number 6 not
Also
here?
not here.
605. If we could just record that, please. And then for number 7 is number 7, Selo Joseph Khadebe.
Maseko, please, Ismaili. Appear on behalf of artist number 7, Opal Moholo from the local bar, and I can confirm that artist number 7 is indeed before court.
Just put your name on the record, please.
Opal Moholo from the local bar.
Moholo.
On behalf of artist number 7.
Okay, and accused number 7 is seated there, Mr. Khadebe. Then number 8 is represented by accused 7, so that's fine. Mr. Manyeki, accused number 9.
As a court pleases, my lady, I confirm that I appear on behalf of accused number 9 and 10 respectively. I am Machini Mutlou from Legal Aid SA.
Thank you, Mr. Motlo. So you for 9 and
10.
10,
As a court pleases.
right? And then for number 11 was Mr. Marcano.
As a court pleases, my lady, I appear for number 11, together with my
Mr.
colleague,
Shabla.
Shabla.
Number 12, Ms. Mhlameli. Is she present? Sarah Matawana Mhlameli? Oh, she is present. Good. And your legal representative?
I appear for
Mr. Mazibuko, you for number 11. Okay. I mean number 12. And then number 13, Mr. Magashule, is he present? Thank you. Mr.
My
Hodes?
lady, now please explain to the accused were given designated spaces.
Oh, I
They have
see.
a piece of paper in front of each of them. telling
I
them
can't
where to
actually
sit.
see it, unfortunately.
So that's why I wanted to explain it to your ladyship. So there,
I
accused number
see.
13 is present. For the record, my lady, I appear for accused 3, 4. I was standing in for 6, and 13 with my junior Miss Governor would be for all of
Thank
those.
you. I can't see it, so these are obviously due to COVID regulations.
Yes, my lady, that would be.
Good. Then number 14, Belina Molikwe. She's present. Legal representative for number 14.
I appear for accused number 14.
Thank you, Mr. Mary. And then number 15, Makepe.
So
He's present.
I also appear for him.
Okay, so you are appearing for
It's 1, 14 and 15, my lady.
1, 14 and 15. All right. And then for Mr. Fenter is Mr. Van Stappen.
Skulpik, initial CJ, KZN bar.
And is Mr. Fenter present?
Yes.
Thank you, Mr. Fenter. All right, I think all the accused, save the ones we've mentioned, are not here. I'm not sure. I just want to place on record there was some confusion about whether the pre-trial matter would be today or tomorrow. And what was decided is whoever is here, we would deal with the pre-trial today. Also, for purposes of clearing the court in terms of COVID regulations, it would be better. So we will deal with that, and whoever's not here, and if by some reason they think it's tomorrow, when they get here tomorrow, we'll deal with them tomorrow. So yes, I think we've got that in order. Mr. Denessen, what's happening with the pre-trial?
My lady, as indicated in chambers, it was agreed that the matter be postponed. I can maybe just place on record pertaining to the position of Ms. Charlotta, who is still currently in the United States. The state is busy with a extradition application. All the papers have been filed, so that process is ongoing as we speak. We have arranged a date, the 10th of June. That's the first date that suits everyone. If it's so pleased with the court. And the position of all the accused as previous, as it is.
And each one of them, I take it, is on bail, the humans that are appearing.
Correct.
Good. All right then, gentlemen, by agreement, the pre-trial matter is being adjourned to or remanded to the 10th of June 2022. That's the pre-trial criminal matter, pre-trial hearing. All of you are on bail and you want to be here no later than 9 o'clock on the 10th of June 2022. You all understand that? There's just one query, Mr. Holmes. I take it, who is the legal representative of number 6?
It's a Mr. Mancha. I was just requested by my attorney this morning to stand in on a collegial basis.
I take it that date will suit him.
My lady, my attorney will inform them of the date and ask why the representative wasn't here today, so that we'll be in a better position to
Yes,
relate.
because
either today or tomorrow morning.
Yes, neither my secretary nor I were contacted to indicate to us that the legal representative won't be here. So I'm a little confused as to why that was not done.
I'm in the same position.
Thank you, Mr. Holmes. All right then, just to repeat, then the pre-trial hearing is remanded to the 10th of June 2022. All accused will want to be here at 9 o'clock in the morning. Thank you. I think we can then move on to the civil applications, but I think you would need a few minutes to rearrange yourselves, and so court will take a short adjournment, just so that we can all get ready for the civil.
All right. That's After the first one, then you're gone. Then I'm going to move the other one.
One of the state capture regulations, and then in the alternative, the evidence given on behalf of accused one at the State Capture Commission infringes his right to a fair trial as provided for in terms of Section 35 of the Constitution. My Ladyship, I think with all due respect, I think what is obvious is that this application hinges on the evidence given by the applicant before the Zondo, if I may refer to them as the Zondo Commission, I think it's just easier, on the 28th of August 2020 and then again on the 28th of September 2020. But prefacing that was the fact that the applicant was required to submit an affidavit in response to questions by the investigators of the Commission in January of 2020, and then I think the second one was in February of 2020. Now, one must accept that those affidavits would have formed part of his evidence before the State Capture Commission or the Zondo Commission then. Now, the first affidavit was basically an affidavit where he had been posed with certain questions by the investigators relating to his handling of the asbestos project as it is known, etc. The second affidavit had more particular questions, and that related to a payment of 650,000 Rand into the trust account of a firm of attorneys relating to a property transaction. Now, as I've said, one must bear in mind that those affidavits or the content thereof would have formed part of his evidence before the Commission. Now, the applicant in his founding affidavit, and my Ladyship, I have referred to it in the references in my heads, has said that he gave answers and he gave evidence at the Commission which became self-incriminating. And that, I don't think that is in dispute. Now, what is in dispute is that the respondent says that it is not relying on any evidence which the applicant had given at the Commission, etc. It takes a further point and it says that the applicant is rather vague in what he has said. Now, the respondent has attached those two affidavits to its answering affidavit, and that would be at pages 947 and 974 of the papers before your ladyship. Now, if one looks at those two affidavits, the first one was made and attested to on the, I may just get the correct date here, January 2020, and the second one was attested to on the 3rd of July 2020. So one cannot argue that the applicant did not render evidence to the Commission which did not self-implicate him. The respondent says,
Let me just understand, are you saying all of his evidence is self-incriminatory and it cannot be relied on?
well, there are large portions, and especially those set out in the two affidavits, which was also before the Commission, that where he incriminated himself. He was asked questions about his handling of the asbestos project, the approving the project, etc., awarding it, etc. And at one stage, I think in his affidavit, he says that I now realize in hindsight I did not handle it correct. Now that evidence has been placed before the Commission. Now, if I may refer your ladyship to the heads of argument at page 15 and further, that's where I discuss the evidence as such. We say in its founding affidavit, that would be the heads of argument at paragraph 44 and page 18 and further. This is what the respondent says, and it's just a brief.
Sorry, give me a moment.
My apologies.
Paragraph 44, you said.
Yes, on page 18. Now, this is a brief synopsis of what the grounds the respondent relies on in opposing the application. It first of all says the relief sought by the applicant is legally inept and ill-conceived. Then it says the applicant has not indicated what portions of its involvement in the asbestos project became known to the state through the evidence before the inquiry. Now I will return to that. It cannot be said with any degree of probability at this stage that it was any self-incriminating evidence that Mokezi gave to the inquiry which has led to the institution of the prosecution in question. Now I have referred your ladyship to the particular portion in the respondent's answering affidavit, and that would be page 863 of the papers, paragraph 48. Now, for the purpose of the corruption charge against Mokezi, in the criminal trial then, the state has not sought to rely on any self-incriminating evidence given by him in the statements he made to the inquiry. As such, the statement of Mkolisi Dukuhana constitutes material evidence and facts which the SAPS could take into consideration when determining whether there should be further investigation into the allegations made by Dukuhana at the inquiry and what he deemed the asbestos size. My ladyship, we don't have any quarrel or quibble with the fact that the state can rely on Dukuhana's evidence or then use it for further investigation purposes. That is not the issue. The mere fact that the state intends using evidence obtained from the inquiry does not mean that Mokezi's evidence, insofar as any parts thereof may be self-incriminating, will be used at the criminal trial. Now, my lady, we say against that background that you have to decide on the relief sought by the parties. We say that the applicant has been criticized for not furnishing this honorable court with enough detail to substantiate his allegations. However, we submit that it is not necessary for him to do so. We submit that the Amelia has to show the balance of probabilities that his right to a fair trial has been infringed, and there is no need to furnish a detailed summary of the applicant's evidence before the State Capture Commission. We submit, and I think this is very important, that it's not the minute details of the evidence that should be considered,
Which
but rather
paragraph
the
are you reading from? Which paragraph?
paragraph 50 on page 19 at the bottom of it.
Yeah.
Let me repeat that. We submit that it's not the minute details of the evidence that should be considered, but rather the source or origin of that evidence. But then we say there are a few salient aspects which emerge from the respondent's answering affidavit. My lady, and we want to submit that this is very important. The respondent, or maybe let me start this way. If one reads the founding affidavit of the applicant and you read the answering affidavit of the respondent, then you have the following facts emerging. According to the history of the matter, a police docket was opened in October 2019. Now, the first entry in that docket, in what we term the investigating diary in that docket, was an entry, I think, by Brigadier Venter to the current investigating officer, Captain Collins.
Well, I know the history. Perhaps you need to make a point around that you're relying on.
Is that is when the police investigation allegedly started. But the point is this, is that it appears that from the outset, what the investigating team was interested in was the evidence given before the commission, and to see if they could trace anything on the website of the commission with regard to the asbestos project. Now, the next aspect is that the docket was only officially registered in February 2020. Once again, no explanation as to why it took them 4 months to register the docket. The third aspect which we say appears...
Just a minute. Yes, thank you.
The third aspect which we say is salient from the answering affidavit is the fact that they are clearly relying on the evidence of Mr. Dukuana, who testified before the commission in 2019, if I remember correctly. But then we say the state does not entirely exclude the possibility that it could be relying on some evidence of the applicant before the State Capture Commission. And we say that based on the following, and if I may read to your ladyship, if I just would find it, it would be the second file at page 863.
Just for the record, I only have one file.
As your
But
ladyship
I
only
do
have one file.
page 863, yes. Page 863.
Yes, and referring to paragraph 48, where the Director of Public Prosecution says the following. In addition, Mokezi himself sets out how the inquiry gave notice to him that he had been implicated or possibly implicated in alleged criminal activity, including corruption and fraud, by Margaret Ann Diedrichs and Sori, and it provided copies of their statements on oath to him. That being the case, it cannot be said with any degree of probability at this stage that it was any self-incriminating evidence, let me rephrase that, any self-incriminating evidence that Mokezi gave to the inquiry which has led to the institution of the prosecution in question. We submit that does leave a bit of an opening, opens the door to the possibility that they might have relied on his evidence. Now, if we go to, if I may return to paragraph 51 on page 20, we then say if the state, as far back as October 2019, already had made out a case against the applicant it has failed to explain the delay in arresting him. The state only on 4 September 2020 applied for a warrant of arrest. Now, Ladyship, one will see this against the background of the contentions by the respondent that they have been investigating this over a period of time. We then say, but then the applicant is only arrested almost 4 weeks later, coincidentally after he had completed his second stance as a witness before the State Capture Commission. We then say, if the question begs, if the state has built its own case against the applicant independently from the State Capture Commission and does not have to rely on his evidence before the State Capture Commission, why has there been a delay in arresting him? Once again, against the background, we've already made out a case against him. On the 4th of September, we applied for a warrant of arrest. We wait almost 4 weeks before we arrest him. And we only arrest him after he has testified before the State Capture Commission. With all due respect to the respondent, that does not make sense. We then say, if what the respondent alleges is correct, then there is no reason why the applicant could not have been arrested and charged in February 2020 or even earlier. There is no logical explanation from the respondent for the delay in arresting the applicant and charging him. We say on a conspectus of the factors as set out above, the version furnished by the respondent just does not seem probable. Now, the applicant in his founding affidavit refers to one court appearance where my learned, the prosecutor in this matter, Advocate the Nation, addressed the court and apparently made the remark, the evidence before the commission is a nice to have. Well, now that is rather a significant remark to make. We say there are simply just too many coincidences in the timeline of the investigation against the applicant and his subsequent arrest. And then we enumerate them on page 21 in paragraph 56.1 to 56.6.
Just give me a minute. You're reading from what? Which document?
Paragraph
The finding
56.
The founding affidavit or your
No, my
evidence?
head. Sorry, my lady. On
Yes.
page 21.
Thank you.
And then I enumerate the factors there. I'm not going to repeat them again, my lady. I've already referred to them. We then say in paragraph 58 on page 22, in summary of that, it appears that it's rather a matter of deciding, after the applicant's second spell as witness before the commission, that there was now enough evidence to arrest the applicant and build a case against him. If you look at the timeline of the events as set out in the answering affidavit by the respondent, it just does not make sense. You are trying to convince the court that your investigation was to a large extent independent from that of the State Capture Commission, that the evidence that you gathered was independent from that which arose before the State Capture Commission, but yet you don't arrest. You wait till this man has completed his second stance before the State Capture Commission. Our submission is that that is not probable. My Ladyship, but then in our conclusion, we say on page 22, paragraphs 59 and further, we say it's our respectful submission that on a consideration of all the evidence before the Honourable Court, the conclusion is inescapable. Without the self-incriminating evidence of the applicant before the State Capture Commission, the respondent would not have been able to prosecute him. It is further clear that the evidence of several other witnesses before the State Capture Commission played a crucial role in the decision to arrest and prosecute the applicant. And once again, we don't have an issue with that. I could not come across any law or decision saying that the state would not be entitled to use the evidence of one witness at the State Capture Commission. What will happen to that evidence at the later stage is a different argument for a different day. What we are saying is that there appears to be little, if any, evidence apart from that elicited before the State Capture Commission against the applicant. And when I say elicited before the State Capture Commission, I'm referring to the evidence of the applicant. In the premises, we submit that the applicant has made out a proper case for the relief sought by him. My lady, I have dealt in my head in the beginning with the background of the matter. I have referred to the relevant sections of the relevant regulations. And for my learned friends' sake, I have worked on the regulations as Regulation 8 as amended. So I don't see it deemed necessary to repeat any of those. I have referred to a ladyship here and there to some decided cases, which I said I'm not going to repeat. That is basically my answer.
Thank you, Mr. Mary. Mr. Castle.
Maybe you will stop because my 30 minutes is up. Already, can I ask you to please turn to my learned friend's heads? 2 points I want to mention his heads.
Sorry, what page, Mr.?
Page 8, paragraph 27. And then I'll deal with the law. He says 8.2. No evidence regarding questions and answers contemplated in Sub-Regulation F, and no evidence regarding any fact or information that comes to light in consequence of any such questions or answers shall be admissible in any criminal proceedings, except in criminal proceedings where the person concerned is charged with an offence in terms of Section 6. We're not dealing with Section 6. That, my lady, in March 2018, by the new president, was amended. And the amended version reads like this, my lady, and the lady should have seen it time and again in our heads. A self-incriminating answer or statement given by a witness before the commission shall not be admissible as evidence against that person in any criminal proceedings brought against that person constituted in any court, except in criminal proceedings where the person concerned is charged with an offence in terms of Section 6. So what are we dealing with, my lady? We're dealing with the first set of regulations, for want of a better term, can I call it former President Zuma's regulation. Now what former President Zuma had in mind was people come to the Zondo Commission, the Chief Justice, the Acting Chief Justice Zondo Commission, tell their story and get forgiven. His regulation was akin to a truth and reconciliation. The Guptas will fly in from wherever they are in the world and come and tell their story. Mr. Essa will come. All the people, my lady, that squandered billions and looted billions of rands of South African taxpayers and South African poor people's money would come and tell their story, and all are forgiven. That's what President Zuma had in mind when you read Regulation 8.2. Then, of course, came President Ramaphosa, and he changed Regulation 8.2. And that's why I said, my learned friends, heads of argument, do not disclose the course of action. And what Regulation 8.2 says, my lady, it says what any criminal lawyer, and I know most of the people in this room are all criminal experts other than myself, but most criminal lawyers know the tried proposition that constitutionally and in terms of the common law, a self-incriminating statement is not admissible. And perhaps the best exposition of that, my lady, is the judgment of Mr. Justice Ackerman, that of Mr. Justice Sachs, that of Mr. Justice Chaskelson in the Ferreira versus Levine case, although it dealt with the 417 in terms of the Companies Act. But the law is spelled out there. It's actually tragic that we should come and debate, my lady. What all these learned people know is so trite. When a self-incriminatory statement is sought to be presented to the trial judge, counsel will jump up and in America says, I claim my Fifth Amendment. In our law, in terms of the Constitution, it's, my lady, 35.3J. Can I just read that out to you in English? .353J. It deals with the fair rights trial. And that was its emphatic. Not to be compelled to give incriminating evidence. And my lady, that's now enshrined in the Constitution. But as Mr. Justice Ackerman points out, is part of our common law. So my lady, if I may just say, this debate about the regulations, with great respect, it's easy, my lady. When in the criminal trial, an accused is required to deal with a self-incriminating statement, that's not admissible. Now, my lady, for purposes of the hearing today, I would submit it's good law. Assuming Mr. X or Miss X appeared before Mr. Justice Zondo, and their counsel, for whatever reason, was remiss and didn't jump up and say, that would incriminate my client. That will not assist the prosecution, because it's part of your constitutional, part of your common law right not to be incriminated. So when the criminal trial starts, and of course some would like it to start sooner.
Well, then it goes against the point that initially the state made, that he did not claim that privilege at the commission. So he can't now come and say, well, you know, you can't use it, because in any event the Constitution entrenches that you can't.
I agree. So my research of the law, my lady, is that even if you did not claim it before Justice Zondo, you still can't use it in a criminal trial. Clark, kaput. Because that's your constitutional right, both constitutionally and common law. And my lady, if you accept that proposition, then this entire debate becomes academic. Because it's when, in context, the trial court is dealing with it. So, to that extent that our heads read, but you didn't claim it before Mr. Justice Zondo, I accept. It's ideal to claim it. Or maybe not ideal to claim it, because the Commission's function, after all, is the pursuit of true facts. The Commission's findings are not binding. It's not even opinion evidence. It has no evidential material in the trial. So, some would argue, if you want a proper commission of inquiry, so the second proposition I want to make, my lady, about fair trial rights. Now, fair trial rights, my lady, as any seasoned criminal lawyer, and I would submit any seasoned honorary lawyer knows, it's to be seen in context. And perhaps, my lady, the best illustration is that of Justice Streicher writing for the full bench in the Viljoen case, which we referred to in our heads of argument, where he said it's a two-pronged approach. He was, of course, dealing with a confession in that case. But he says the first thing you do is you examine whether there is a breach. Once you find there's a breach, you see the magnanimity of it, the degree, the context, and you say, does this result in an unfair trial? If yes, well, that's the end of the matter. It can't go, the trial is unfair. But that's a judgment call the trial judge does. Now, before I move away, my lady, there's one judgment that I want to refer your ladyship to, because I think it's so elucidating, because none of our learned friends have quoted one case, my lady, where a court interfered pre-trial judge. Not a single case. With all this learned counsel, my lady, they could produce one case. Because the law is clear, you don't do this at this stage. Now, my lady, the judgment I want to refer your ladyship to, perhaps, that really illustrates the principle, is that, my lady, of no less than Mr. Justice Harms in the King case.
Is that the one in your head?
In my head, my lady.
Okay, now, so I've read it. That's
And
fine.
my lady, I just want to make this one point to your ladyship, my lady. where he says the following. He says, your ladyship is right. Fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. Then he goes on. The purpose of the fair trial provision is not to make it impractical or to conduct a prosecution. And then, my lady, two more statements on the main content. At the end, your ladyship will see, he says, one can add the tendency of such accused instead of confronting the charge of attacking the prosecution. And that's exactly what's happened here. It's a matter I might have to deal with further if my learned friends persist in unfairly and ungraciously attacking the prosecution. Then he says, it is the duty of the trial court to try a charge and to ensure that the trial is fair. And if it turns out that it was not, then any conviction that follows might be set aside. And it goes on, my lady. So, my lady, your fair trial rights, my lady, it's not something in vacuum. As my learned friend now, my lady, barely 30 minutes wants your ladyship to determine a trial that might last, my lady, for 2 weeks or 4 weeks. And then, my lady, I want to turn to something else, my learned friend. Because when I read his heads about, I seriously made the submission to your lordship, to your ladyship. It doesn't disclose a course of action. He refers to the old regulation, and then, my lady, if your lady turns to paragraph 23, this is what he says. Clearly, my learned friend didn't have the opportunity, my lady, of talking to these papers, because he says, historically considered, the relief the applicant is seeking in practice amounts to a permanent stay of prosecution. Further argument in this regard will be advanced at the hearing of this application. Now, two propositions I want to put to your ladyship. The first is this, my lady. You can't advance argument from the bar. You've got to make out your case in your founding papers. And there's not a word in the founding papers about delay. Secondly, my learned friend knows, my lady, that what he's asking for is the most draconian step you can ever think of, my lady. Consider the facts, my lady. His client, my lady, is instrumental in giving an award, now known as the Asbestos Award. According to my learned friends, for the third and fourth accused, they were going to count how many roofs got asbestos. Well, that counting, my lady, resulted in a contract of just over 250 million, of which your ladyship knows 230 million has been paid. This is serious money, my lady, for counting how many roofs got asbestos. Of course, my lady, the third and fourth defendants didn't conduct the work. They farmed it out to a third party, accused number 8, for 43 million. For the number 18 to it, my lady, he gave it to number 10 for 21 million. Now, what your ladyship knows, it was a contract given contrary to section 217 of our constitution, which for any tender, my lady, is the Bible, is the gospel. There must be a process that's fair, transparent, competitive, and efficient. This is why Justice Foreman, my lady, in the all-pay case, my lady, all-pay 2 says, fundamental, if you don't comply with that, it's an irregular contract. Otherwise, we'd be bankrupt as a state. There was no compliance with 217. No compliance, my lady, with the relevant provisions of Public Finance Management Act. There was, my lady, flagrant breach of Treasury Regulation 1686. Now, what that says, my lady, if Province A has given a tender for stationery for 10 million rands, another province, my lady, Limpopo, requires the same item during the same period then it's inefficient to have another tender. You can piggyback on that for the same duration. Well, my lady, what they piggybacked on this one, without Treasury approval, because Treasury will never give the approval, is what they did is, from this contract was coming to an end on the 31st of August, the Gauteng one. On the 4th, my lady, 27 days left for the 250 million rand contract. They piggyback on it. Different specifications, my lady. Different time period. Can never be done in that time period. And Gauteng says to them, go on a competitive bid. So what does Mr. Mokesi do, my lady? He makes 55 million rand, authorizes payment before the work even started. Well, this, my lady, is wholesale plundering for the country that has no service at the moment. Now, I'm presenting that to your ladyship to understand the enormity of this case, so that it's not lightly taken, my lady. Let's go to court and have this approach, my lady. We kick it out. And we're not successful, we go on appeal, because then the culprits never come to face the book, my lady. They want the day of court, they must facilitate the trial. So, my lady, insofar as accused number 1 is concerned, there's nothing in the founding papers, my lady, that makes out a cause for a permanent stay. I think my learned friend will concede that. So let's look at the relief he wants, my lady, before I wrap up with him. My lady, the good news is I won't repeat what I've already said to your ladyship in the other matters. He says, declaring that the indictment, insofar as accused number 1 is concerned, is premised on evidence obtained from the Judicial Service Commission of Inquiry. Now, my lady, it doesn't matter, because the test is, when he's criminally tried, nothing that is incriminated himself can be used against him. But of course, my lady, to prove this case is not difficult. All you've got to do, my lady, is to look at the records of the Free State relevant department, and you'll find common cause: no compliance with 217, no compliance with PFMA Act, no compliance with Regulation 16A6. Somebody's got to accept responsibility, my lady. Whether it's the Premier in his capacity as the executive authority in terms of 125 of the Constitution, whether it filters through to what extent it's called accountability. But this particular individual, we know, my lady, that he was the man in charge. So he's got a prima facie case to answer. We also know, my lady, from subpoenas issued to banks, that the recipients of these particular fraudulent tenders or irregular tenders made payments. Whether he's sorry as to what the payments were for or not, my lady, whether that will meet the test of, excuse me, my lady, Rex versus differed, whether you'll meet the test that it's a reasonably possibly true version, the trial court will decide. For me, my lady, the answers are very clear, frankly speaking, to be brutally frank. But that's something for the trial court to deal with. So, my lady, that relief which he asked for is simply inept in law. Then he says, directing that the state's reliance on accused number 1's testimony and evidence from the State Capture Commission renders any
where?
trial against the applicant. I'm reading prayer 2 of his notice of motion at page 3. That, my lady, is the fair trial argument. And I've dealt with that, my lady. The lady was seeing our heads. We deal with the Sheikh case, we deal with the Tent case, we deal with the Van der Merwe case, the one of Justice Bertelsmann sitting in the SCA as acting judge, full bench decision. We deal with the Viljoen case and a whole host of cases. All of them says that's for the trial judge, not for this court, my lady. Declaring that accused number 1 is excused from prosecution in terms of rate 8.1 of the state capture regulation. How can you be excused from prosecution? He's the man must answer why you gave 230 million rand of the ratepayers' money in this province for a contract that ultimately was not. Number 10 says I wasn't even paid by 21 million. And number 8's got the same complaint. What the true value is, my lady, we'll never know. We can venture and guess, but we'll never know because there was no compliance with basic competitive process. And my lady, there's a whole all pay ends off. It starts off with Steenkamp and it starts off with all those tender law cases. They says you must have a competitive process. Otherwise, it's money for buddies. So you can't get that relief. In the alternative, he says, the evidence given on behalf of accused number 1, a state capture commission infringes his right to a fair trial as provided for in section 35 of the Constitution. Now, section 35 is your fair trial rights. That, my lady, and I've accepted that even if his counsel didn't object before Mr. Justice Zondo. Incidentally, in his first statement, he doesn't talk about payments. None of these payments feature. But it doesn't matter, because the principle is you can't leave evidence against an accused which incriminates himself. That principle against self-incrimination is law. Is there anything else? My lady, the terms of reference, your ladyship will see that the terms of reference of the Zondo Commission is in fact says, and he simply makes a recommendation. It's not binding. He's saying to the president, chase these people who have committed looting. And one of them, my lady, is the asbestos project. We've put that in our heads, my lady. The ladyship will see that. My lady, we submit a hopeless application. It's regrettable, my lady, that the ratepayer or the taxpayer has to even pay for this application. But there you have it. It's a hopeless application. And we will ask the ladyship to dismiss it with us, my lady. It is a matter serious enough, my lady, to warrant 2 junior counsel. Because, my lady, there's at least 4 or 5 counsel against me on this matter. I do accept, my lady, the issues are not complex. The cost is always in the ladyship's discretion. That's all.
While you're on the question of costs, Mr. Kassim, I know you asked in, I think, in your answering affidavits as well as your, I think your heads, the cost of 3 counts. So if it's not that complex, why should I authorize, let's assume at the end.
I'm being over-ambitious, I can see.
So you, because I'm not sure why I should authorize the cost of 3 counts.
No, I accept it.
Mary, you want to reply now, or would you?
No, I don't have any
Teacher.
reply. I stand by my argument.
Say again?
I stand by my argument. I'm not going to reply.
No reply. All right, I see that it's 11:10. Would this be an appropriate time to take the tea adjournment before we commence with the next session? Matter? Thank you. We'll take the tea adjournment.
Get to
Listen, Lawrence, I wouldn't trust a CB on my back.
Corresponding again.
Yeah, trust you right.
so abusive.
It's amazing. It's amazing.
Enter the bathroom or one stuff is Yes, yes.
Let me go this side.
Wonderful. We're gonna hear you now.
Oh, do you know why it's getting that?
No one is.
She has a friend. Yeah,
It's gonna be worse. It's gonna be worse. I'm saying if you put it next to it, change it to that side, it's gonna be worse. So I'm just explaining the real concept.
Yeah, I think so. I got Yeah. I also said this. So I just have to
We can also clear them and something
We have to look.
Oh, now I'm hungry. Tebogo?
Oh, you are. Are you arguing now? Okay, and then who else is it after you? Is it just you guys?
It's me. I'm doing the Saudi one now.
Yeah.
Then there's one other. Then I think it's me on ice. Then there's another.
That could be done today.
Yeah.
Oh my god. It's nice to be in it. You have no idea. I've been doing this in the case. And there are no, I mean, there's maybe like 2 adults in that whole room. And the rest of it, Zoom. Fucking nightmare. Yeah, like Zoom is thing.
You see, you said the other day he's going to come out with whether you like it.
Yes. I saw that.
Yeah, so
I don't want to see my accent.
So you see, he came here.
You then, brother? And the articles in Yes. It's me. It's me. You can send me an email. Yes. Just tell him we're filed and tell him we filed an exception. They are failing to comply with the rules so that we can get a date. So they've not served I think they've not served the doctor. They've just served the Minister of Police late last year. So they are taking forever just to comply with the rules so that we can get a date. But we are now filed an exception. We want to set it down to remove the system. But your applicant is not welcome to drop me a mail so today and tomorrow I'm going to High Court. You can drop me a mail, I can respond to the I'm sending it to you right now.
So to chance on section 30. You go to them and say, do you wish to give before you can get a certificate and proceed? They issued the certificate, they admitted that in the process. It's a monster.
Judge Wazir, maybe we should remind people. Maybe people should be reminded.
Section 34 where you hold the position.
Yes.
You're aware of the inspection, fraud, exceeding 100,000 positive obligation charge. Section 27 says, before a person can be prosecuted with an offense, there must be a certificate before it's obtained. The person must be approached.
The move a TRC.
Sorry, I
Net die uitzending. Argumenteren ook.
She's beautiful. She's a dog.
Where have you looked? This thing.
For the youth.
Doesn't know all around getting a sense.
Goed. Zijn er dan redelijk stiptelik hier bij jullie nog?
Het is een goede raad voor kinderen. Wacht met kinderen. Mensen moeten eigenlijk rechter muziek gehoord hebben. Maar hij neemt voor door die appel op, hij helpt het uitdoen. Het is rechter nodig die zo. Ja, maar zolang je rechter, permanente rechter bent.
Ik kan niet onthouden, zij die procureer werkt is, maar het is zo zelfterecht.
Dat is ook raar. Ja, meneer is raar. Die bijl, wat zij gezegd,
ja, het is
zij geweest. Meeste mensen, wat ik dan moet gedraaien. Terug bijl.
Yeah. To the left. Immediate left.
Yeah.
Yes. Nothing is left.
Ja, maar... Ja, nee, maar dit is ons bij die volbank hier. Die zijn hier. Het was haar veld 1 jaar. Het veld waar die boven gekregen.
Ja, dat is inderdaad zijn meneer, want dat is
ja, ik heb eindelijk een idee met Jannie opdracht dat Mike Evans die zaak gehad voorheen en ja, voor jullie was Willem Jedler. En ja, toen daar nou problemen ontstaan en Dawie Hubert en Jannie Kreer, denk ik, ja. En nou moet Jannie ingaan vir 'n rugoperasie. So, miskien is ek weer oor 'n week of wat terug. Met daai ding.
Ja. Maar as dit geval is, dan werk nie meer op plan om te
Ja. Kyk waar koop hulle daai ventjies.
Ja. Het is eigenlijk niet gewoon om iets te zetten, maar die goed zo is maar eigenlijk die kan hoeven. Maar ik denk dat meer dat je maar net iets voor zien, die camera's en altijd op kijk, je moet zo'n stukje voor slaan. Ja, maar ook niet in hierdie hoog is.
Hoe lang is jy al hier?
Een hele leven lang.
Dit is waar jy groot
geworden.
Zwart alles.
Zwart, ja. Ik nou die mensen met zwart. Ik was in de school heb ik zwart. Ik heb wacht in gemeente dat ik er aan droom uitgegeven. Dat mijn droom. Maar terug van Procedural en ja, ik heb afgegaan met droom. Ik zie nou klaar gemaakt. Ik kijk naar af en toe. Maar goed, dat is ook dit verkeerd in het leven. Maar ik denk ook maar die kans en geleentheid met de uit...
Ja, you know what I got, die gaan het goed van ons.
Dit is maar waar, mensen is beroeps, maar het is niet passie. Die is verkeerde redes. Dan val hulle ook pas so uit, weet, gaan doen ander dinge, bly in die praktijk. Dit is eintlik sleg.
Our worst.
Ek het nog met my assistent Melodius gesit.
They think that for the voicemail to Melanie.
My keer daar, hy was nog in die ou gare. Dat sy 5 jaar verklaar om die automatische graad te kry. Ja, meneer Jasper, hy het nog moet vertel, daar was so min mense in die beroep, dit is 'n teruggezochte beroep. 5 jaar verklaar en dan die automatische graad gekry, jy het nie eers 'n graad gaan swart. Ja, dinge het allemaal verander.
Ja.
Meneer gaan glad nie oorslaap nie, meneer gaan sommer weer bietjie terugry.
Dan ook maar wat die gebeur, maar sal maar kyk. Ek doen baie werk saam met Christen. Meiring en dan miskien sy oorbly sal ek maar oorbly, hy ons maar môre.
Ek het net lekker net om so 'n bietjie rustiger.
Ja, wel ek kom goed vir die kantoor aan, man. Ja, kyk. Like sien dit is vir die donker. Ja, you have things that are
Don't look there.
Ja, wel in die middag van Bloemfontein se kant af is die verkeer. Die verkeer is in die oggend van die suide af en in die middag van die kom met weer terug suid.
Since I've submitted this, that's why last time we had a big and then she that's why but
Is the court ready? Can we start?
Yes, please.
This is the third floor. Number 3rd floor.
Second.
And your lunch is 1 to 2. Not like Cape Town, to 2:15 now. wife complaining, says, I look ugly on TV. I said, don't worry. Others are still coming who's complaining.
Thank you, Mr. Boots.
Thank you, my lady. My lady, it's just for record purposes, this is the application of accused 3 and 4, Mr. Saudi and the corporation called Blackhead. In this matter, my lady, I am assisted by my junior Miss Governor and briefed by BDK attorneys because the attorneys changed, but my junior remains the same, my lady. My lady, as I told your ladyship in chambers, it's not my intention to quote from my heads. I will make short reference to my heads and Mr. Kassim's heads, but I'd like to set a chronology first, my lady, and my junior Miss Governor has undertaken, if required, to type up the short chronology because it will be of assistance to all of the matters from a certain point, my lady, and this comes from the papers, my lady. So the starting point, my lady, and it's what we need to bear in mind in the build-up to where we are today, is the first step, my lady, is the report of the public protector, the former public protector, Ms. Tuli Madonsela, on a state of capture, which is Annexure PES1 to our papers. And that's the genesis of everything, my lady. Everyone speaks of the genesis, but that's where this all began. And that document, my lady, is dated 14 October 2016. So we're talking, my lady, about a process that's been ongoing now for an excess of 5 years. So it's not something that just happened overnight, but my argument at the end of the day, my lady, will still be that we're dealing with something that is sui generis because it has not as yet passed constitutional muster or been fully decided by our courts, and more specifically the Constitutional Court. So if we move forward from that first date, my lady, the next step in the process, my lady, was when the Commission of Inquiry was appointed on the 23rd of January 2018. This, my lady, is PES2 to our papers, and it's common cause, my lady, these dates, so that that was then done by the former President Zuma. And then the next step, my lady, is when the terms of reference were promulgated, and that was some 2 days later, my lady, on the 25th of January 2018, and that's PES3 to our papers. There's a major legal change that then took place, my lady, that's been referred to as common cause between the parties, but doesn't seem to have been recognized by the courts. And that, my lady, is even though this Commission of Inquiry was appointed and the terms of reference were promulgated by the former President Zuma, when our current President, Ramaphosa, took over, he changed or amended the very provision that we're dealing with in this matter, my lady. And that's why we talk of a genesis and another genesis. One could say that would be the genesis of the problem. Because Regulation 8.1 provides that the person must answer. The former Regulation 8.2, and it's in our papers, my lady, I'm just going to read it out to you. The former Regulation 8.2 went further than the current Regulation 8.2. So previously, my lady, it was, as Mr. Kassim said, it was like almost like a Truth and Reconciliation Commission, where people who came forward and told the truth were then believed and granted some form of indemnity in that. Not only their testimony, but everything secured in consequence of their testimony. Now, I quote from the regulations as they were. They said in consequence would be inadmissible. So when the new president took over, he changed the rules of the game, so to speak, my lady. And he said only the evidence that is self-incriminatory will not be utilized. Now that, my lady, has not as yet passed constitutional muster and hasn't been considered by the courts. In fact, I believe it was pointed out by my learned friend, Mr. Kassim, to my junior Miss Governor, that the Constitutional Court missed that point, as I'll show your ladyship in the one case where they refer to a footnote, which I'll refer your ladyship to, where they quote the incorrect terms of Regulation 8.2. So it's something with respect that has not as yet been decided. But now moving forward, my lady, in the chronology, if we turn then to the dates that are opposite to this matter, and more specifically to my clients in this application, Mr. Dukwana, and he's got the various spellings of his name in the papers, testified before the commission, that's the Zondo Commission, on the 5th of April 2019. And it's common cause, my lady, that when he did so on the 5th of April 2019, even though the investigators and the commission were aware of what he was about to testify about, and I believe extended their terms of reference to incorporate it, but that's not the argument for today. At that stage, they did not notify Mr. Saudi that he was going to be implicated as was required in terms of Rule 3.3 of the Commission's own rules. So we had the testimony of Mr. Dukwan on the 5th of April 2019, unchecked, without any due regard to the rights of Mr. Saudi and Blackhead. No notice was provided. What then happened, my lady, is on the 19th of August 2019, Mr. Saudi was given a notice for him and for Blackhead to, in terms of Rule 3.3, to say that Mr. Dukwan is coming back and he will be implicating you. You are welcome to attend the commission, which he did, on the 27th of August 2019. So we had first hearing of Mr. Dukwan, no notice, no presence. Second hearing, notice and presence, and he was present. So that takes us forward to the 27th of August 2019, my lady. What then happened, my lady, is the commission proceeded. An interview was requested with Mr. Saudi and representing Blackhead for the 7th of October 2019. They made a request to him, we want to interview you. Now that interview, request for interview, is a compulsion to provide information about yourself, as is evident from the annexures, my lady. That resulted, my lady, in the interview by the investigators on the 22nd of October 2019. This is where the issues that are current and opposite to this matter become very relevant, my lady, because the next thing that happened is that he received a summons to appear before the Zondo Commission on the 11th of December 2019. We know, my lady, that there were delays caused by the COVID infection, which resulted in his first appearance on the 7th of August 2020. So it's several months later, my lady, and at that appearance, I represented him, and it's a common cause that I stood before, as he then was Deputy Chief Justice on, and I said, my client is here to testify under compulsion. All of his rights in relation to a trial are reserved in terms of Section 35 of the Constitution, and we will be cooperating fully as is the requirement in terms of the rules, and we proceeded. Now there's a whole hullabaloo, if I may say, created about this. The state, and I need to pause here, my lady, to make it myself very, very clear. I do not engage in personal attacks on any of my opponents. I refer to them as the state collectively. That would include Mr. Donation, Advocate Samaru, and Mr. Kassim and his team before this court. They are one organization. They represent the NPA, the prosecuting authority. So it's not attributed or attributable to any particular individual. We can speak of the state collectively. But what happens is they then said, you should have claimed the right to privilege every time he answered a question that might have incriminated him. But that's changing the rules, my lady, because we went before. The Deputy Chief just said, these are our rights, this is what we expect, and everybody acquiesced at that stage.
Kassim acknowledged that and has
Yes,
acknowledged and conceded that that was not correct, because I pointed out that his stance now has changed.
My lady,
since then.
I'm going to be more polite than your ladyship and say the state, because I've been...
no, that's correct. That's correct. I concede that fully. My learned friend didn't have to say,
I don't think we need to, unless it's relevant, then I'm going to have to accept that they now currently accept what the position is and not what they had initially made out.
That's a major concession which doesn't appear on the papers. It's important that we emphasize it. And more specifically, my lady, I'm going to forewarn my learned friend in this regard. In paragraph 44 of his own, he changed his stance as well. So there are too many changes, my lady, and that's the whole crux. The ladyship has hit the nail on the head with respect. Is they keep on changing the goalposts and changing the rules. And it's not a personal attack. I'm speaking of the state, my lady. I'm very, very clear on that. And when I say so-and-so said on the day, I want the court to read in the state said. But I have to identify the person that said the different things at the different times. So that concession is golden, my lady, and it goes against everything in the papers. But I'm not going to retract or go back on that. So we move forward, my lady. We on the chronology, because that's crucial. So what then happened, my lady, is Mr. Saidi was called back to the Zondo Commission on behalf of Blackhead and himself once again on the 19th of August 2020. The same warning was issued by me at that meeting, my lady. And thereafter on the 29th of September 2020. But in the interim, my lady, the rules of the Commission changed again. So how do the rules change again? So in the first we have the rules that say you cannot be, no evidence that's found on account of anything you say and consequence of what you say can be used against you. Then it says you can, it changes to only that which you say that self-incriminatory can't be used against you. Then the rules changed, my lady, and they said, going forward, from now, all the evidence obtained at the Commission can be utilized by the investigative authorities. So as even Mr. Cassim said, started off like a type of a truth and reconciliation, come tell everything, then perhaps they realized this is more than what we bargained for, so now we're going to prosecute. But it changed, the rules changed. So one has to ask through this whole process, my lady, and this is my question that I'm directing at the state. What happened to the fundamental rights of an accused person in terms of Section 35 every single time you changed the rules? Because you ignored them. And Section 35, let me say it now, my lady, is all-inclusive. It says every accused person. It doesn't distinguish between cases of 255 million rand as opposed to 250. It refers to every accused person. But I'm still progressing through the chronology, my lady. So as soon as Mr. Saidi finished testifying before the Commission on the 29th of September 2020, what happened next? He gets arrested, my lady. 30th of September 2020, he's arrested. So you have to look at the dates, my lady, because they draw a picture and you join the dots and you see everything unfolded. You ask yourself as an accused person, was I doing the right thing to go and self-incriminate myself against all those assurances when at each juncture they merely changed? And does this pass constitutional muster, and can I actually be prosecuted? Because the day after he left the Commission, 29th of September 2020, he gets arrested on a warrant, my lady, that's on the papers dated 4th of September 2020. So you have to ask yourself, if a warrant is something your ladyship knows, it gets executed with absolute expedition. You don't hold back on it. But yeah, inexplicably, and no possible explanation has ever been tendered for that conduct. And I pause at this juncture already, my lady, to ask how fair is that process, and what happened to the constitutional rights of the accused at that juncture. You've played ball, you've come forward, you've given documents, you've attended interviews, you've given self-incriminatory evidence, you've given documents, you've given your bank statements, you've done everything, and then you get arrested. And the states say now, as your ladyship knows from the papers, oh, but don't worry, we're 205, we've got Section 205 subpoenas. They don't give your ladyship the date. So it's very easy after the fact. Once I've got all the evidence from the accused to go in Section 205 of the subpoenas, because they don't give us a date, my lady. And what we now do have, which I'm going to show to your ladyship, is we have the investigation diary, which shows when the investigations began, which lead us back to exactly the same thing. So moving forward, my lady, from the arrest of the accused, or Mr. Saudi, and representing the corporation, we then have, my lady, a judgment of the Constitutional Court that my learned friends rely on heavily, and this is the 2021 Volume 5 decision. And I need to highlight the date to your ladyship, and I know my learned friend has made the concession, but and this is in fact the point that he told my junior, so I'm not stealing the point. That judgment, my lady, which is referred to as the secretary judgment in the heads, at 2021 Volume 5, page 1, the decision of the Constitutional Court was delivered on the 28th of January 2021. So I know it's been conceded, but one cannot argue that that would have bound Mr. Saudi and Blackhead at their appearance at the Zonda Commission on the 7th of August 2020. It's just illogical to suggest that. But just to point out to your ladyship that if one has regard to it's a unanimous decision on delivered by Justice Jafta in that matter, and more specifically, my lady, at paragraph 24, he has regard to the regulations, and with respect, and I say this with the utmost respect, my lady, I don't want to be criticized again for saying something that's untoward. He quoted the wrong provisions of Regulation 8.2. In footnote number 18, my lady, it's common cause that this is incorrect. And here we have exactly what I've referred to, ladyship. He says, in paragraph 24, at the last sentence, he says, the prohibition, well, let me read the whole of paragraph 24, if I may, my lady. In exchange for compelling witnesses to testify before the Commission, Regulation 8.2 prohibits the use in any criminal proceedings of evidence adduced at the Commission. That's important, my lady. Evidence adduced at the Commission. It doesn't go for. He says this prohibition does not apply to a trial relating to an offence under Section 6 of the Commissions Act or Regulation 12. The prohibition extends to derivative evidence that may come to light as a result of the witness's testimony before the Commission. That evidence is inadmissible in criminal proceedings. Highest court of the land, my lady. But they've made a mistake. Footnote 18 that they refer to says, Regulation 8.2 provides no evidence regarding questions and answers contemplated in sub-regulation 1, and no evidence regarding any fact or information that comes to light in consequence of any such questions or answers shall be admissible in any criminal proceedings, except in criminal proceedings where the person considered is charged with an offence in terms of Section 6 of the Commissions Act 1947 and Regulation 12. So you'll see there, my lady, it includes evidence in consequence of the self-incriminatory evidence. So that should be
derivative evidence.
Yes, my lady, and that's in the judgment of the Constitutional Court. That should be the be-all and end-all of our case, my lady. But unfortunately, it doesn't stop there, and I'll explain why. We go along in our sequence of events, my lady, from the 28th of January.
If we know, and it's common cause, that the court made the mistake of relying on the old regulation, and we know that the situation changed some time before this judgment. Are we still bound if we know there was a mistake and if it's not applicable to the current case? Interesting question.
It's a very interesting but very difficult question that I'm not going to venture an answer to, unfortunately. I'm going to leave that to you.
Is going to tell us something about that. Are we then still bound by that if we know, and all of us agree and accept, that there was an error and the pronunciation of the court was on the old regulation?
Now, my lady, I wouldn't stand before your ladyship and mislead you in that regard. I'm an officer, and it was pointed out by my learned friend to my junior, Ms. Governor. So I wouldn't be the person to come and say, well, you're bound by that. It doesn't end there, unfortunately, as I said, because we are all aware that it's the incorrect regulation. We cannot wish it away as much as we would love to, but so be it. What then happens, my lady, is we appear in this court, my lady, before your ladyship brother, the Judge President Muzi, on the 2nd of November 2021. And that's a very important aspect, my lady, and the state was represented by Mr. The Nation at that appearance. I'm going to refer to the state, and as I made it very, very clear, my lady, and this is in the papers, and this is why it becomes so important, my lady, to see what was actually stated, and I'm going to refer your ladyship. It's in our file, on page 1504.
Second.
1504. My lady, it's very difficult because at the time I was confused and confusing my two clients. At 1504 is directly appropriate to hear, and there's an inaudible that we have agreement as to what was left out there, my lady. So at 1504,
me get to it, please.
As your ladyship pleases.
Yes.
Thank you, my lady. At the foot of the page, my lord, my lady, you'll see it's the last person speaking, Mr. Dinesh, on behalf of the state. Then the issue pertaining to, on what this case is based on, what I read myself, I suffice to say as previously, the testimony during the Zonda Commission is and it says indistinct, but the word that's been agreed, my lady, is nice. Is a nice to have. But that is an admissibility question. And we turn the page, my lady, to 1505. Admissibility of evidence. In my view, it cannot be decided to or adjudicated before the trial starts. Now, my lady, that's the crux of the case we have today. You've heard the different, and that's why I have to point it out. Unfortunately, the whole reason why we're here is they the state put forward a procedure, which I'm going to read to your ladyship now, which will show that it doesn't tie in with the concession made today. It would have done away with the whole case, possibly, my lady. The court says yes, that's the judge president, my lady. The state says, I think it should be addressed in a trial within a trial of some form during the trial. Then the judge president says, seeing that Mr. Hodes is inclined to lodge a formal objection to the prosecution, I think that can come true in your answer to his, it should be his founding affidavit. The state says, as it pleases the court. And then the judge president says, and ever if they are so minded to reply, let them reply, and the presiding judge will then make the judgment call whether it is something that ought to be dealt with during the trial or at that stage. States, indeed. Judge President, yeah. So what I require now is firstly for the parties to indicate whether, bar all these issues canvassed now, the matter is ready for trial, and if so, then we should look at trial dates, and only thereafter will I be able to give a map, a roadmap as to how we are going to deal with the other preliminary issues. Now this, my lady, is what happens in what we call case management meetings, judicial case management meetings. It's akin to a pre-trial in a civil matter. It's where we try to narrow down the issues. At times, my lady, even in the previous meeting before this date, there was a debate about the provisions of section 212B of the Criminal Procedure Act and whether the state was compelled to send a notice in terms of 212B to narrow down the issues. The state was reluctant to do so. The JP said, you will do so because that's the practice in this division. And I support that practice, my lady, because it narrows down the issues. And that's what the whole purpose of 212B is. And I will address your ladyship on 212B as well. My lady, the next and final date that in my chronology, my lady, is the release of part 1 of the state capture report. It's referred to in the state's heads of argument. That date, my lady, which is crucial to this matter, is 4th of January 2022. And the reference there, my lady, is to paragraph 549, where there's a peripheral mention of this matter, my lady, of the asbestos audit. So that, my lady, would sketch the background, and I would ask your ladyship, I will highlight different aspects, obviously not the rest of Mr. Saudi, when I deal with my later applications. So I don't repeat the exact same date, but I will, my junior Ms. Governor has undertaken to type up these dates in a chronology, which I believe would be of great assistance to everybody, my lady. Now, my lady, let me pause, and I'm going out of my order, but I had said to your ladyship in chambers that there was a very, very recent case that assists us in this regard, my lady, and that's the decision. I have a copy from our learned friend, and I will, it's a reported decision, my lady. I have a copy for your ladyship as well. But one can find it, my lady, in the January 2022 law report. It's the normal law reports, my lady, not the criminal law reports. It's a decision of Judge Winterhalter in the Gauteng local division. And essentially what he was dealing with here, my lady, was the signing off of a class action in the Steinhoff matter, which everybody has read about. And in the, he declined the application, he refused the application to sign off, even with costs, and he based it on the law that would apply to such again, because that which had been placed before him didn't make out a case, which is what I will argue is the case here, my lady. So I say it's opposite, it applies. I've read and I'm aware of the precedents and all the authority that my learned friend quotes for the reluctance of our courts to entertain piecemeal applications and adjudication. But I say, my lady, that this is part of the case management. One cannot be expected to go through a whole trial, my lady, only to hear afterwards, you trod all over the accused's constitutional rights. We shouldn't have had this trial, in a trial involving so many people that was going to run for years, my lady, and involve millions and millions of rands. And let me take it back, my lady. The same would apply with respect to a shoplifting charge. If you don't respect the constitutional rights of an accused person, you cannot have a trial. And the relevant portion of the judgment, my lady, is at paragraph 297. In the law reports, it's on page 512. And this is where Judge Unterhalter summed things up very eloquently, and he says, that is an unusual judgment to ask of a court on a question of law. Questions of law ultimately have a right answer. That answer may not always be easy to give, but it is the function of courts to decide questions of law in a binary way. A cause of action is either allowed by law or it is repugnant to the law. A cause of action is not to some degree recognized by law. That being so, there is no reason to defer true questions of law to the trial court, and for two principal reasons. First, the trial court is in a better position to determine a true question of law. Of course, as our courts have observed, there may be circumstances which evidence may assist in deciding a question of law. Then it may be prudent to leave the decision to the trial. But where that is not so, the certification court should decide the question of law. Second, class actions, as in this case, often involve complex litigation of importance to many with significant consequences of both expense and expectation. For this reason also, the interests of justice require that a certification court should not permit a class action to proceed on the minimal premise that the cause of action is not hopeless. Too many risk too much to proceed on this basis. Now, I draw a parallel, my lady, between a class action which requires certification and a complex criminal matter of public importance, as emphasized by the state, where you come before the judge present and you say, we're trial ready, we have problems with this accused, this evidence, that evidence, but please set us down for trial. It is incumbent on the court, as Judge Unterhalter said, to examine that as a question of, say, is this case in fact ready for trial, and can it be argued that the state is ready? And I will illustrate to your ladyship that it cannot ever be the case on the facts before your ladyship. My lady, going through the papers, your ladyship will know that the answering affidavit by Advocate Somaru also referred to the nice to have, and that 205s had been obtained, but they don't give dates, and she highlighted that Mr. Mpambani is deceased. And as has been considered but appears in the papers, I'm constrained to mention it, my lady, that we ought to have reviewed the decision because we acquiesced, which is not pursued. Then, in the reply, my lady, we once again, and it's common cause, referred to the state's representative and said that the evidence in the commission is nice to have, and it was not the basis of the evidence to be used at the criminal trial, which we say is totally not the case, my lady, if regard is had to the investigation diary and the dates that appear there. We also highlighted, my lady, that this case isn't based on a need to eradicate the asbestos. It was instruction to perform work on RPW, where these parties were required to audit, not to remove. And the state has already mentioned that the dates of completion were impossible. It could never be the case. But my lady, we've got the Auditor General's report. It's in our papers. Everything is provided there, my lady. Now, my lady, I'll pause at this juncture before I get to the conclusion to turn to the heads and only highlight. I'm not going to quote heads as I told your ladyship. My lady, in our heads, I have very limited references. My lady, my submission is the crisp issues identified in paragraph 12.
Just a minute.
Hold your ladyship, please. paragraph 12, we identify the crisp issue and say this matter in a nutshell concerns the state's ability to use self-incriminating evidence given at the State Capture Commission and subsequent criminal prosecutions, more specifically the criminal prosecution of Mr. Sadi and Blackwood. At paragraph 16, we deal with what transpired, and your ladyship will see at 16.1 we say it is undeniable that the genesis of the criminal investigation emanates from the State Capture Commission. That's at 16.1. In 16.6 we highlight the reference to the testimony from the State Capture Commission is a nice to have, as I've referred to your ladyship to. At 16.7 we refer to the answering affidavit where it's even denied that this is relevant, this comment. And at 16.8 we say it bears belief that the state conceded the testimony from the State Capture Commission, which would include Mr. Sadi's testimony where he gave self-incriminating evidence with respect to both himself and Blackwood is a nice to have when the law specifically the State Capture regulations expressly prohibit this. So what we then receive in the state says, my lady, is nothing short of astounding.
I didn't hear that, Mr. Hill.
What we received in response in the state said is nothing short of astounding, and I will show you, ladyship, why I say so, because it's much nicer to read the words than to attribute them to somebody without having an immediate backup. So what they're saying, my lady, is that this is in paragraph, I'll start at paragraph 3. They say that the orders sought are untenable in law and are sought prematurely devoid of context and impact here. That's at the top of page 3 of their words, my lady. In paragraph 4, they say rather it is only their self-incriminating evidence which cannot be used against them. And my lady, this is when the confusion starts to creep in and where I need to highlight precisely why we are before your ladyship today. We refer, my lady, to paragraph 23 where they refer to the tint, and it's a quote from a case, my lady, that after the underlining there's a reservation about the ratio of that case, which says there can be no absolute rule in this regard, however. The court's door should never be completely closed to litigants. If, for instance, a warrant is clearly unlawful, the victim should be able to have it set aside promptly. If the trial is only likely to commence far in the future, the victim should be able to engage in preliminary litigation to enforce his or her fundamental rights. It's very interesting, my lady, how we highlight different aspects of the judgment, but there it is, black on white, my lady. We then turn, my lady, and it's a build-up, my lady, as I said, to paragraph 44. In paragraph 32 is where they say that they had been investigating, but as your ladyship will note, there's no dates. They don't tell you what investigation they did prior to the inquiry. So one would expect if the case was, this is a nice to have, we may use it, we may not use it, we're not committing ourselves, which has been the general attitude, you'd expect them to say, well, we started investigating Blackhead and Mr. Sadi in 2005 when we heard this, and this is what we've done. But they don't ever take your ladyship into their confidence and share that information. This continues, my lady, in paragraph 34, where they refer to a document that was used at the commission that Mr. Sadi was questioned on the cost of business schedule, on which its common cause was interrogated, and a version was elicited from him, in which they now you've heard all of you read about in these papers. And then, my lady, at paragraph 39, they say that the statement that he gave after all the interrogations, where he gave his version, PS 17, isn't privileged because no self-incrimination was claimed. You'll see that, my lady, in paragraph 39. I will just quote to your ladyship the last 4 lines. Be that as it may, some of what is stated by Mr. Sadi with reference to this matter in PS 17, which is attached to his founding affidavit, in respect of which no right against self-incrimination was claimed, is. And then they set out. So, my lady, these heads of argument show that the case has changed drastically with respect, my lady, but I still need to get to the crux of why we're here, my lady. And this we get, my lady, starting at paragraph 43 on page 25 of
Sorry
the
to
rules.
interrupt you, but
Sorry,
just a
madam.
gentle reminder
Yes,
that
ma'am.
we're supposed to be 30 minutes.
I'm almost done, my lady, I can assure you. This is my last point, my lady. Paragraph 43, be the above as it may, the state prosecutor, advocate, the nation has indicated that the evidence from the inquiry is a nice to have, but that the evidence was not the basis of the evidence to be used at the criminal trial. This makes sense given that knowledge of the existence of the award of the asbestos project, the applicant's bank accounts and the payments made therefrom were required by the state independently of any evidence given by Mr. Sodi to the inquiry. And herein lies the rub, my lady. Paragraph 44. That being said, the position of the state in this regard may well change. My lady, how can you put somebody on trial and tell them, here's the docket, have a look, prepare your defense, but we might change our mind later on. Look here, my lady, this in this regard may well change once the trial gets underway. That's the flaw in the whole argument, my lady. They say to you, don't rule, let the trial court rule. They say, well, we're not committing ourselves now. Should the state decide to use any evidence emanating from the inquiry, we submit it is perfectly entitled to do so, given the purpose of the inquiry and the recommendations already made by its chairperson referred to below. What the state cannot do is to use self-incriminating evidence given by any of the accused during the inquiry against them. This is by virtue not only of section 35(3)(j) of the Constitution generally, but expressly by virtue of regulation 8(2) quoted above. My lady, all that we're saying is this court needs to hold the state to its word, but it keeps changing, and that's the problem we have. You cannot say, I'm respecting your fundamental rights, claim them in the trial, let's go to trial, when you've ridden roughshod all over them, and claim that you're entitled to do so and that you don't have to make an election. And my lady, if I have anything, I'll use it in my other application, but I'm aware that I'm past my time limit. Thank you, my lady.
Thank you, Mr. Lutz. Mr. Kirsten?
My lady, please keep me to my time limits. I won't be offended when you stop. My lady, can I just start off with the judgment of Mr. Justice Unterhalter? I'll show your ladyship why it's totally irrelevant. What this is, my lady, is an application for a class action. Then if you turn to, now class action means you've got to have a cause of action before you can have a class action. And in his conclusion, you'll see he says there's no cause of action here. And I think it's at paragraph 174 of this judgment, my lady. Can I just go there, give you the correct reference? Maybe 137, my lady, 137. He deals with why there's no cause of action. 137. Now, can I just summarize what it says, my lady? What 137 says, my lady, going back to Force versus Harbottle and the well-known judgment, my lady, in company law of Percival versus Rights. The relationship does not give rise to fiduciary duties owed by directors to the shareholders of a company. However, the directors may owe fiduciary duties to shareholders in special circumstances, in addition to the fiduciary duties owing to the company. The duties owed by directors to the company does not preclude duties that may also be owed to shareholders. However, the duty that the director may owe to a shareholder is not based upon the relationship between the director and the company, nor is there any general duty that is owed by directors to shareholders. So the particulars of claim in this case, I think it was prepared by one Mr. De Bruin. You'll see in the conclusion section where he says, your draft particulars of claim, which you put in a class action, does not disclose a cause of action. It's like an exception. Of course, my lady, if you want to see the case against Mr. Sodi in this case, you read the particulars, you read the charge sheet. It's there. So that's the first point I want to make. The second point I want to make, when your ladyship has regard to the chronology, your ladyship must take into account that Mr. Sodi gave evidence after the amendment by the president, the present president, not before. In that regard, my lady, I didn't make much of the fact that my learned friend didn't object when Mr. Sodi gave evidence. And I'll tell you, my ladyship, why this may be academic. I didn't object, but section 3(4) of the Commissions Act, your ladyship will see that in the fullness of time. Section 3(4) of the Commissions Act says that's exactly what you should do. Every time your witness gives, you must jump up and say, that may incriminate you. And from the transcript, my learned friend didn't do that. But I'm not making an issue out of that because I accept that constitutionally and the common law, you still can't use it in a criminal trial. Not because he was, I'm not doing it because he was remiss. I got a more subtle point to say it doesn't matter. There's of course another point to it, my lady, and I've read Mr. Sodi's evidence. On his version, he did nothing wrong. There's no incriminatory evidence. On his version, he got a contract. He tries to explain the contract. I'm going to show you the contract now, the farcical contract. And on his version, all the payments are made to different public officials. There was a reason why I made it. Whether the trial court would believe him or not is another matter. We don't have to answer that now. So his evidence, to a large extent, he didn't say I did anything wrong. Nobody, my lady, nobody in the Zuma Commission ever came up and accepted responsibility that 3 billion rand or eventually 30 billion went missing in the Zondo Commission. Nobody accepted, my lady. I've been following that. Nobody came and says, I was wrong, please forgive me, South Africa. Everybody passes the buck to the next guy or the next lady. Now, my lady, it is very important that my learned friend turned on this point here. And that is the point what he was doing. Because you will see, my lady, and I just want to go through my notes on rebuttal. If you look at paragraphs 4 and 7 of our learned friend's heads of arguments, they say the instruction to perform work, he referred to it, the IPW, dated 2nd December 2014, which your ladyship will find at page 611 to 612 of the record.
Just a minute, I'm just trying to find a place in the head. You said 4 and 7.
7. Out paragraph 4 and 7 of the heads. I'll tell you what it's all about. It comes clear to you. Your ladyship looks at the record 611 and 612. It makes reference only an audit assessment. So in other words, you had this contract for, in fact, 250 million, 255 million. We know 230 was paid. They say all they had to do was go and count roofs of 300 houses.
300,000.
300,000 houses, that's what they say. We know they paid somebody 21 million. But in fact, your ladyship, the appointment letter, which is 1 October 2014, signed by Mokezi at page 601, and the SLA, the supply level agreement, signed by both parties, 602 to 610, reflect that the joint venture was appointed to assess, audit houses, roofing using asbestos material, handling and disposal of asbestos sheets to an approved designated disposal site. See definition of project, that's what my note says in the SLA. And in the appointment letter. The appointment letter covered the replacement of the material with SABC approved materials. The scope of the work in the JV's own proposal at page 599 covered removal and disposal of the product as well. He's got a hard case to meet in the criminal trial, my lady. This was a sham. I want to then move on, my lady. I'm glad my learned friend says, look, I don't attack colleagues in the matter. And I believe him because he's a very esteemed senior counsel. But my lady, and I'm not casting any blame on him, in the replying affidavit of Mr. Sodi and in the heads of argument, they have a full go at Mr. Van Neysen and the NDPP. They accuse them of misrepresentation. They accuse them of dishonesty. And that's why the striking of application is there. They take the dignitas on what, my lady, is contested legal and factual matters. Now, my lady, when I dealt with the cause of action of Mr. Justice Intelhouse's case, he says you don't have a cause of action because you don't, in your particulars of claim, Mr. De Bruin, demonstrate why there were exceptional circumstances that the directors owed a fiduciary duty to the shareholders. That's not a general law. That's legal argument. Here we're dealing with admissions, which everybody knows, my lady, is for the trial court to determine. But I can't see, my lady, I've read the transcript, no doubt my learned friends have read it. I don't see Mr. Sodi actually saying he's done anything wrong. What then is left, my lady? I don't know whether my learned friend is pursuing the point that we can argue before your ladyship that this must be determined in the criminal trial. if your ladyship sees the court order, can I just get the court order, or Mr. Justice Musi, and your ladyship will find reference in my heads of argument to the judgment of Mr. Justice Haramsa in the security fund case, where he says interpretation is a question of law and not fact. And whether you're determining a contract, a piece of legislation, an order of court, you follow the same principle. You look at the order. Now your ladyship will see all that the order deals with is to say 1 to 6 accused, 1, 3, 4, etc. Must file by so and so date, state to answer, accused to reply, postpone for argument, all accused to be present, court stands down. There's nothing there that says, I've already determined that when I appoint Ms. Naido, Judge Naido, she must now make rulings. There's nothing there. And the court order, my ladyship, you'll see is the same principles apply. You've got to interpret the court order. But of course it's worse, my lady. If you go to 1505 of the debate, it's very clear that His Lordship, Mr. Justice Musi, did not try in any respect to bind you, my lady. Your ladyship will see at the bottom where Mr. Donation speaks. He says, then the issue pertaining to on what this case is based on, what I read myself, I suffice to say as previously the testimony during the Zondo Commission is indistinct to have, but that is an admissibility question. Admissibility of evidence, in my view, it cannot be decided to be adjudicated before the trial court, says His Lordship. Yes, Mr. Donation, I think it should be addressed in a trial within the trial court. Seeing that Mr. Holders is inclined to lodge a formal objection to the prosecution, I think that can come through in your answer too. It's found in affidavit. As the court pleases, says the state. Court, and ever if they are so minded to reply, let them reply, and the presiding judge, this learned judge, will then make the judgment call whether it is something that ought to be dealt with during the trial or at any stage. I just want to develop that a little bit. My learned friend says, look, whatever applies to powerful people, financially speaking, and a shoplifter, there must be an equality of arms. The reality, my lady, is that a shoplifter will stand her trial because she hasn't got the means, the financial means to bring what are, my lady, applications that delay the ventilation of the true facts. So there's a vast difference, my lady. People who bring applications of this nature, my lady, have the wherewithal. And if this is permitted to happen, then you're creating two laws in this country. One for the rich folk and one for the poor folk. It is obnoxious to access to justice. It is something I'll urge this court not to be party to. My lady, just one other aspect that I came across in the heads of argument, and I think it's fair to point it out to you. No, it's the rebuttal. If your ladyship, one can criticize the state, but law is not a perfect art. When you're chasing wrongdoers, you're doing all the chasing, my lady. But my lady, if I were to become nitpicking, if your ladies looks at paragraph 16.6 to 16.8 of our learned friends' heads of argument, 16.6 to 16.8, they say the founding affidavit refers to Advocate Nations saying that the evidence from the State Capture Commission is nice to have, not that the testimony is nice to have. Heads are incorporated in seeking to change the case. Now, it's gone away, my lady, from nice to have to testimony. Now, there's a subtle distinction, my lady. And that is this, my lady. Two things, my lady. The first is this, my lady. You cannot bind the state. If the state wants to draw evidential material from the commission itself, that, my lady, is the very object of item 7 of the terms of reference. That, my lady, has been spoken by no less than Chief Justice Zondo himself, where he says, pursue this, go to the authorities. One of them is the asbestos project. But there's a second leg to this, and that is this. At the trial, if it can be interpreted that what you're putting to the witness, Mr. Sodi or his company, is incriminating, then that's not admissible. So I really don't understand the nuance of the argument my learned friend has presented, with great respect. There is a third leg to it, my lady, and it's not something that I want to delve too much about. But if you go to our heads of argument, my lady, in the Sodi matter, like I say, so Mr. Sodi, and if you go to paragraph 67, where we deal with the judgment of, let me just see if I go to the right paragraph, my lady.
Ferreira matter.
My head, my lady, where I'm dealing with the judgment of, I can tell your ladyship and you can then find it.
Talking about
my lady.
footnote in the Sachs J's separate but concurring judgment in the Ferreira matter.
Yes, my lady, it's a Ferreira decision. So there, my lady, one of the things they deal with, in the footnote to the judgment, Judge Sachs refers to clue evidence, which is your derivative action. Now,
derivative evidence.
Derivative evidence, my apologies, my lady. Now, it may well be that the argument is put, look, from Mr. Sodi's evidence, you have fact clues, according to Judge Sachs, or derivative evidence it's known, and that's not usable. That's be the argument in the trial. Again, my lady, the authority is quite clear, and they refer to a lot of Canadian cases there, my lady. But it all boils down to this, that the trial judge, using common sense and logic, will decide whether these are the fruits of the rotten apple,
poison tree,
as my lady, Mapp versus Ohio, the famous American case, my lady, or whether, as Judge Sachs says, but this was a legitimate, lawful purpose, a fact-finding inquiry. And then, of course, my lady, as happened from Mapp versus Ohio, and then the law changes, you know, my lady, the first judgment I can think of that I came across, my lady, was a matter called Pelko versus Connecticut. And there the judge, my lady, said that this visitor from Mexico was Mexican, my lady. The FBI took him and took him to hospital and pumped his stomach out, and there they found drugs. And it was Judge Frankfurter. He says, no, I'm not admitting that evidence because it offends decency of the English-speaking people. Well, my lady, he was Austrian, he wasn't English-speaking. But that gives you a vivid idea, my lady, that the derivative evidence or the clue facts, each court will apply its own minds. How did you get it? You went to Kessem's house with a warrant to search that he's dealing in drugs, and there you found this child trafficking. Some judges will say, of course I'm going to admit that evidence because of the horrendous nature of public interest. After all, we have to preserve the dignitas of our children. Their safety comes first. Other judges maybe, my lady, I don't know. But that's a value judgment, my lady. That is what the trial court will have to do, dealing with derivative action and clue facts. Because there was a nuance in my learned friend's argument, my lady, that if he agrees with me, and he's very able, Mr. Sodi never implicated himself in any wrongdoing. But if there are derivative evidence arising from that, that's going to be tested by the trial judge. Finally, my lady, what do you deal with the judgment that based on wrong law? Answer is simple, you ignore it.
Even if it comes from the highest court in the land.
It's wrong, my lady. No, my lady, common error happens. Now, By the way, I can try to argue why it was obiter, but I don't think I want to waste the court's time. It was obiter because all they had to decide is, must President Zuma give evidence or not? It was an urgent application. I'm not saying that to ameliorate the mishap of the court, because there were 9 judges, 9 article clerks, 9 registrars, paid a super salary because these are the brightest people from the university, some imported to do research. There were lots of lawyers, and they missed a basic issue on the law. How can any court be expected to give meaningful effect to a judgment, common cause by all the parties, based on the wrong regulations? You're perfectly entitled to ignore it, my lady. And I can't cite better authority than myself for it, my lady. Unfortunately, I haven't able to find a case, my lady. It's just common sense, my lady. So, my lady, we submit, my lady, that this application must be refused, my lady. If I may just take you to what they're asking for, again, my lady, in the notice of motion, and then I'll come, my lady. Thank you. They say, my lady, declaring that the indictment, insofar as accused 3 and 4 concern is premised on evidence obtained from Judicial Commission, we've dealt with that. They got the 35(3)J protection, common law protection, declaring that the state reliance on accused 3 evidence from the state renders any trial against these applicants unfair and breach of the fundamental rights. Well, that's something they can raise if they're relying on his evidence. I'll advise the state not to rely on his evidence, is fully exculpatory. Declaring the accused 3 and 4 are excused from prosecution in terms of regulation 8.1. That's now rich man's law, my lady. Please, you have a discretion, don't exercise it. In the alternative, the evidence given on behalf of accused 3 and 4 at the state capture infringes their fair trial rights. That's, my lady, we're back to the Falloon judgment. Further alternative relief, ladyship must simply dismiss this, my lady. It's not a discretion. Your ladyship should judiciously exercise. I've, in my practice note, set up, my lady, the current state of affairs as far as discretionary relief is concerned. Here's the court, please.
In reply, my lady, and I'll be done by lunchtime within the time constraints. My lady, what my learned friend forgets.
One moment, Mr. Hudson.
Thank you, Lord. Lady, my junior just points out that in paragraphs 107 to 109 of the Constitutional Court judgment, they again refer to the regulations. But paradoxically, there they got the right regulation, just to point out the regulations. It's, my lady, in the vernacular in this province, achamos.
Ach en nee. It's paragraphs 107 to 109.
Correct.
Thank you. Reply, Mr. Hutz.
Thank you, my lady. My lady, what my learned friend forgets is that accused 3 represented accused 4 when he testified. So it cannot be said that his evidence was not self-incriminatory of accused 4 of Blackhead, because there was a detailed schedule of payments that he himself refers to in his papers and in his heads. So one must take that into account. Similarly, my lady,
Just a minute.
to...
Sorry, just one moment.
I beg your pardon.
Yes.
My lady, over and above that, another important factor, my lady, is he oversimplifies matters when he speaks of the subcontracting of a 255 million rand contract, of which 230 was paid. Because at the end of the day, my lady, what he forgets is that the JV, represented by accused 4, retained ultimate responsibility over the project as the project manager. So one cannot just say you subcontracted. So even though
people or other companies were employed to do certain work, the ultimate responsibility lay with the project manager who signed the agreement. So it will turn on an interpretation of the agreement of the RPW, which was the final contract that was signed. So you cannot, as my friend says, oh, they pulled the wool over their eyes because they undertook to remove. But one looks at the final contract that was signed to see the work that had to be done, which was also evident from his oversimplification of the work done. It was 300,000 houses, not 30,000, not 3,000.
I did point that out.
As your ladyship pleases. The issue here, my lady, that my learned friend hasn't dealt with is the state doesn't retain the right to change their minds midstream. Just like counsel for the defense, my lady, if I make a concession on behalf of the accused is bound by it. There's a lot of authority on that. So when the states say, this is the case that we're going to make out, they cannot, and this remains unanswered by them, states as they do at paragraph 44, we may change our mind midstream during the trial.
Well, shouldn't the trial judge then say, no, sorry, sit down, you're not allowed to do that?
No, my lady, how would the trial judge know what the rules of engagement were? Because we're determining now the rules of engagement. And I'll give you two examples, my lady, where this is protected. If one has regard to practical applications of this right of indemnity, my lady, there are two sections of the Criminal Procedure Act that come to mind. Firstly, Section 105A and secondly, Section 204. And that's where we deal with indemnity. So Section 105A specifically provides, my lady, that once the deal is off, and that's after it's been through a court and everything, it's 105A 10. It says, where a trial starts, then others are contemplated in subsection 6C or 9D.
That's after the plea bargain fails.
Yes, my lady. The agreement shall be null and void. So where a person attempted to secure a plea bargain and it doesn't succeed, it becomes null and void. It cannot be used. Those are the rules that are set out before a trial begins. You can never prosecute. So let's ask the question, could one then say, we're going to prosecute this person. We might use that 105A somewhere in the trial, even though it's explicitly provided that it may not be utilized, but we might change our mind and utilize it. They cannot, my lady, because that's the duplicitous attitude adopted by the state. And this is further borne out, my lady, by Section 204. In Section 204, sub 4, I beg your pardon, 4A, says, where a witness gives evidence under the section is not discharged from prosecution in respect of the offence in question, such evidence shall not be admissible in evidence against him at any trial in respect of such offence, or any offence in respect of which a verdict of guilt is competent upon a charge relating to such offence. So they cannot. And that's why your ladyship seems to have been taken in by the submission that they can change their mind, the trial judge will then decide. They cannot do that, my lady. There's a constitutionally recognised fundamental right that an accused has, and that is to know the case that he has to meet. And he prepares accordingly. That's Section 35. And that applies to the rich and the poor. It's not a rich man's law, my lady. It's everybody's law. So a person charged with shoplifting is entitled to the docket to know what the case is that he has to meet. He cannot be held liable in terms of 105A if they change their mind after a plea and sentence agreement. And similarly, if it's given a 204, they cannot change their mind. Rich or poor, it applies to all, my lady. So that's the flaw with respect to his argument. It has no practical application to be able to say, we can change our minds and the court can decide, because that could mean we can still charge somebody under the old Immorality Act and the court can decide that it's going to hear it. It's ludicrous with respect. So now, my lady, if we look then to the order that's granted, your ladyship will notice, my learned friend makes much of the fact that it was just a timetable, but the judge president specifically said at the top, and we've highlighted this in, and I'll give your ladyship the references at page 1491, my lady.
1491.
1491, your ladyship will find the actual order, and it's in the affidavit as well, my lady, at paragraph 43 on page 1407. And we say that the order provides as follows: having considered the documents which were handed in and after having heard legal practitioners for the state and the legal practitioner for the accused. So it's not just a timetable that was agreed upon, it is with respect to an order that was decided by the judge president, my lady. My lady, my learned friend.
Just a minute.
I'm almost done. My
lady, my learned friend quoted from the overseas authorities. The problem we have there is, as Judge Krichler said in the Wild's judgment relating to unreasonable delay, when we transplant Canadian jurisprudence to our land, the problem is that we're in Africa and sometimes it doesn't grow in our soil. And that's the problem. So there are principles that are applied there. It didn't make sense to transplant the principles because there was no regard to what we regard as our systemic delays. Similarly here, to speak of removal of evidence from bodies, we have that controlled in our Act. The Act specifically provides that you can do so. So that's why it doesn't, with respect, make sense to make reference to that here. My lady, as to the final submission in relation to the error in the Constitutional Court judgment, my lady, all that one can say is that it is the highest court of our land. We take guidance from it, but one cannot take blind guidance from it, knowing that there is an error in the judgment. That was the only point that I was making there, my lady. And I still maintain at the end of the day, my lady, that having regard to anybody's constitutional rights, the state cannot change their mind once they set out what the case is that the accused has to meet. And that's the flaw in the argument here. You cannot say, come cooperate, I'm going to assist you, then utilize that against the person, because then they don't have clean hands before the court. You cannot then say, well, we'll decide midstream, let's go into the trial and let's see how we go. Because then we're dealing with the trials that drag on and have no end in sight. My lady, we submit, particularly if one has regard to even today, my lady, the changing stance from the state as to whether we were obliged to claim a right against incrimination and privilege, which changed from their heads to today. We've made out a proper case, my lady, and we ought to be awarded the costs. Similarly, my lady, they don't seem to have pursued the striking out application. I made it very, very clear, my lady. That's the essence of our case, is that the state kept changing their mind, as your ladyship has seen in action before your ladyship today. How can one then say, how dare you say that I'm bringing my public position into disrepute because I changed my mind, when they themselves change their mind as we go along? One cannot, my lady, adopt that attitude with impunity. And as they quoted from the King judgment, justice is a two-way street. I agree with that, but you have to apply the same principles of fairness on both sides. And we cannot say, because it's a big case, we're going to now override all the rights of the accused. Similarly, if an accused is charged with rape or the most heinous murder, we still have due process, my lady, and we have to abide by the fundamental rights that are in the Constitution. When a prosecutor or the state say one thing and do something else, or if a defense says one thing and does something else, one cannot just say, you cannot mention it to the court because you're attacking their dignitas. It's not a case of dignitas. We hold the position, if I spoke nonsense to your ladyship or I misled your ladyship on that judgment from the Constitutional Court and my learned friend, but I pointed it out to his junior, then I must take responsibility for my action, and that responsibility is in the trial and in the costs, my lady. And I say a proper case with respect has been made out and should be awarded with the costs as paid for in our notice of motion, and similarly the striking out should be dismissed with an appropriate cost for them. Thank you, my lady.
Really, I completely overlooked the striking of application. Can I deal with that when I deal with, subject to what my learned friend says, when I deal with the case for applicant number 30?
Well, there is also one in this matter, so
Yeah.
Unless you have any objections to that,
The
Mr.
same principle.
Hertz, unless you wanted to be dealt
No, my
with
lady,
now.
I've adopted a very practical approach, my lady. Whenever, because I know that I overstepped my limit of time, I know that there are things that there's a cross-pollination, so I don't have an issue with that, my lady.
So you'll
I'll
deal with it at that
there,
stage.
and then
Yes,
your
my lady.
ladyship, either it's good or it's bad, I'll deal
Thank
with
you.
it.
Because I have a right of reply even for accused number 30, Mr. Magashule, right at them. So I don't
Yes,
have an issue.
well, you will be obviously allowed then to respond to the striking off application in respect of accused.
Yes, my lady. Thank you.
I see that we have reached 1 o'clock. We'll take the lunch adjournment, and then when we return, we will deal with accused 11's application. Okay, I just want to get these. Adjourns.
No.
I'll just repeat it.
This one. No, that's what so when you meet him, it's
You told the sandwich partner states where you don't have a choice, you just eat what's there. I feel sorry for those politicians. I made that decision because of
Is there more wood?
Yeah, October 1. Yeah.
You take it back on the 5th of September.
Just before that, the zone commission. Yeah, I went there twice.
3 August.
But I went there. No, you said you did. Yeah. No. So I did submissions twice.
On the 14th of May?
Yes.
Yeah. I actually got it. Remember when I first gave you a rate certificate? All I could do was select it.
And they sent second questions.
So 14 May,
which I then responded to.
And then.
On 1 October.
Yeah.
Edwin was arrested
Yes.
on
Yeah, that's one.
Yes.
the first of the
When you were arrested on the 1st of October?
on the 30th of September,
Then was arrested
and then was arrested the following day. So he was Wednesday, I was Thursday. But I was due to be arrested on the 30th as well. Just
But how did they come to you and say,
No. I handed myself
West.
to the offices of the lawyers.
Your ways?
Yeah.
When you arrived there, what?
Well, they started the process of registering the case and signing those papers.
Because we were asked to go and then we presented you.
Then we appeared on Friday. So we spent the night. Those were arrested on Wednesday. They spent the night on Wednesday in Pretoria. Then they moved from Pretoria to Bloemfontein on Thursday. So we all met on Thursday. We spent the night. On Thursday we appeared.
Yeah, I know it's in that.
Do you want to tell you that?
So they could not catch me on the 30th of October. Yeah, only wanted me. I was already on the run. I was already on the run. And then on Thursday, because I was Peter Marisburg, I went to Durban for the 12 years in the office of the artist. So
I found this here. It's
3 August.
Tell me what references you want.
in the head, they give us section 34, section 27.
Responses. Then here
You can get rid of all of this, nothing else there.
Edwin's net. Come and take Edwin's
You
files.
have to put it down.
I will definitely visit these 2
Sorry, give me so much
Just check
more
on the
space.
date that we received. 23 of what?
23 August 2019.
And I was
I will just
after
a minute.
the submission
After-
of my
just
second
a minute.
affidavit, and I will tell you why.
After you appeared, after you gave evidence, you want to submit that now. No, it can't be. But it's all
Only
on
two
this in
affidavits
2020.
before my appearance. After my submission of the second affidavit, only after appearance of court, I've never submitted any pictures of the court. Yeah. And what is also interesting on the document and actual things
That's cool.
one of the witnesses is the yeah.
I've got one.
Share witness. So what's his name?
But then it was before you gave evidence.
Before.
When did you give evidence? Because I think that's important. Because before you gave evidence to Okay, maybe check.
Are you with me?
Maybe, yeah, I understand. But maybe
I
check
gave two
the chronology.
Okay.
It's a certification. So then when we continue and say, I say, my suggestion was basically is confirmed what you said. And you say, confirm what you said. Even if he reads the things you read from the transcript.
This one is 2019.
Yeah. It's just great from watching my hands.
It's towards lunchtime. Then you can do that. Let's go have a look here quickly.
So that's a security.
There's one difference I wanted to give for AIDS. Same point now.
After 2019, questions and answers. In 2020, but it was more than once.
Transport them across.
So what I've done,
Do you have to read anything before on minutes there?
No, I'll tell you what. Right now, we're going to do
Before the commission. Not the
on the internet. Yeah.
Careful to look at the instance of abuse of power and that the policy does. The following things. They were right out of the block of the investigation. What's you've seen here. It's a factor. It should take to conclude before the report. Before the report came out, the very worst. It stinks on both sides.
In fact, the report concerning the asbestos
He was arrested 13 November 2020 on section 34 of the dash. That's the starting point. Okay. Miss Chilotta, we'll go back, sorry. Chilotta makes a statement on 5 December. Chilotta testifies on 6 December. Okay. 2019. Okay. And he was arrested 13 November 2020. And section 34 allegations, we go to court. And during the dialogue
so with regard to this thing,
when did we get to the of July 2020. I've got it. 19 July.
Didn't you say it's the eve of the hearing? So you said it would be argued on 23 July.
So that was a Monday.
Oh, okay.
Have a look.
Let's see what we send there. The dates are sent. Yeah. On on the eve of hearing, the 19th July, paragraph 61. You see that? Yes, that's the second instrument. July, Friday.
That's the week 19 to 23 July.
No, he doesn't. He just shoots from the usual source.
Yes.
I think what this is that 61 is that. It's page 36 of the founding papers. It's paragraph 60 and 61. But 61 is the code, and it's on page 36. How's it, Joe? Good, good. Yeah. Lots of fun. The only person's collecting. I can't talk in 30 terms because you got microphones to use. You tell me when you want to deal with that section 27 thing. What? Page 37. I said I have to take it up graduation. I heard what she said about graduation. No, Lisa picked it up on the phone. I took this. She did give me some message. Excellent. Excellent. I'm very comfortable. PFMA issue. Okay. So
Yes, oh, okay. Where are you from? You know Nelly Casino? Nelly.
Oh, no.
She was a major.
Yes, it's an album.
ah, yes. Now, sorry, when you're saying Kesson, my head is just going.
Oh, yes.
How are you?
Also from Victoria, nice to meet you. I'm a Victoria girl, but I'm not sure you
Nelly was the state for many years. But then she actually came back.
You went back home.
Yeah. But I was still doing like I did my PhD there. I was MA from 95 to 97.
Okay, when did you do that?
John Campbell.
Ah, okay.
Yes, thanks so much.
Oh, and this is my people, sorry, I was
Hi.
Oh, hi.
Nice to meet you.
But really nice necklace that you can follow
Yes,
over
that's
the border.
All right. Thanks.
Yeah, no, it's fine, I just want to pick it up.
Anytime, anytime. Can you go, right? Or no, okay.
Why do you look like you're going to fish in clothes?
There's proof. No. I say things. Really for to finish, I will look on my and then on our way here, it was all over the place. And in court, he fell asleep to be fair.
Oh.
Yeah, I was staying here. That's a Victoria, yeah? Right, listen to this thing. Thank you. Do you know what we did the that client of yours, that chartered accountant, the current couple on the side. Yes, very. No, my wife wants to.
Doing online shopping.
And my wife wants to pay for spectacles. Not me. I know that. Now we're using credit card to get more to
3 times the amount. No, I told you something. Yeah, should be good, you know.
Yeah.
Cashback, basically. Oh.
Yeah, I think
Yeah, you definitely wouldn't have gotten any points there. Defeated.
Yeah, could you have used you count points that special
I think the second one in good, yes. But the first one,
The new idea was all of you come up, please come. But she was a local teacher, she's in a night group.
Yeah.
This is Lindsay.
I was just like,
you count. Everything is going green. We're going green. What are you talking about? It's still
Sustainable fuel.
Sustainable
I was
fuel.
thinking about driving and thinking this engine is going to see space. You know what the green is.
Yeah.
I was
And
very
you-
worried that this. Say that it's taken from the report indictment. Where we get it from is in their section 2 and 2B notice. That's on page 633. specifically paragraphs 12 to 14. Sorry, 615. Look at paragraphs 12 to 14. This is the case with an advanced section. Yes. But they paragraph 42, they will say is an executive authority. No, that's our, 651 is our answer. Theirs is 633. Now, they want to then jump and say, rely on 1 period of the Constitution. It's minutes, but their 212B says he's an executive authority. It's the issue was, one of the titles of Constitution, we are challenging the title of the Constitution, which is nonsense.
Okay, ja, want hij zou maar sturen dat hij dan nog
This is the answer.
iemand zei dat het niet afgeladen. Okay, we do need the all of you.
But there's a contradiction. Just look at this 25. They say what we
So een soort van een draft charge.
of this act is paragraph, right? Magashule qualifies as such. A person has strong because that he was at least 2009 to March 2018 Premier of the province. In such capacity, he exercises all executive authority.
Okay. Ja, Mark is dus maar. Ik zie je later, zoek je nou dat verstand niet.
Let me say, as such, goes only to the out. It's the Constitution that determines. But the reality is, in the 227 the Constitution, they say it's a clear from A. Yes, there is a reference to the Constitution elsewhere. But they say it's a clear from A that makes it an executive. So that is factually not the case. And if they say there is a
something just cool for the summer. But here you are, HSBC you should have negotiated We're all guilty, but let's do something about it. Yeah, look, you did say, you did say to me that you had some role. I'm just asking whether we could perhaps have a look at it before we receive your 8-1 so that it makes sense of it. Yeah, but there's a right sense of it. I don't know. Okay, yeah, well, as I think I sent you an email saying obviously that we need that but yes, okay, well, anyway, yeah, all right, just you Jens, you gave an email as well forwarding it to us. Thank you. Keep on. Bye.
There's only one file anyway, so it's not.
Don't get comfortable. Putting your stuff in last file, I don't know if Constitution.
notice that you have left a file. Thank you for that. The only difficulty with that is it's not paginated, so I will hang on to the original bundle that I had. And
there's a copy. Finally, once again, for record purposes, I'm appearing for accused number 11, Wise Men Zulu, together with my junior Shabalala. The application, my lady, regarding accused number 11 involves about two issues. The first issue is the one that has already been canvassed and dealt with by my two previous colleagues, and it relates to the newly amended regulation 8.2 of the regulations on the State Capture Commission. For that reason, my lady, I do not propose to waste a lot of time on that. I also am aware of the decision of the Constitutional Court in this regard, and the issues that your ladyship has already raised around it. What I propose, my lady, to do is to submit then that despite the decision of the Constitutional Court, it may be wrong, yes. My lady, the important approach here is to bear in mind and remember that despite the regulations, despite the decision, in terms of Section 35, an accused person is entitled to a free trial, a fair trial. My lady, the new regulation, the amended regulation 8.2, refers to a self-incriminating answer or a statement given by a witness before the commission. That is as far as the amendment goes. I will submit, my lady, that upon close reading of this, a self-incriminating answer is one thing, and a statement is another, because between the answer and a statement, there's the letter A, which clearly distinguishes the two. My lady, I will submit that in reading the statement, the amendment, the court must do so in light of Section 39.2 of the Constitution, which says, when interpreting any legislation and when developing the common law or customary law, every court, tribunal, forum must promote the spirit, purpose, and objects of the Bill of Rights. Having that in mind, my lady, then we have to look at what happened, what was the chronology of events then leading to the arrest of accused number 11. My lady, it is common cause that accused number 11 was first approached by investigators of the State Capture Commission. On two occasions, he was requested to submit affidavits.
I made a note that the initial statement, although referred to in your founding affidavit, was not attached to the papers. I'm not sure if I didn't look in this bundle that you had, or this file that you had left there, but that first statement, although referred to, as I say, a copy of that was not attached.
Yes, but it appears it was not attached. It's not attached to the main application.
Okay, is it in this file that?
That is correct, ma'am. My lady, then it is also common cause, then there were certain written questions that were forwarded to him by investigators. And then to which he provided written answers on the 14th of May of 2020. Already what is important is that subsequent to that, on the 3rd of August of 2020, he was then called upon to testify before the commission. He testified in August, and on the 1st of October, he was arrested. With regards to the arrest, my lady, my first colleague who addressed you on this regard referred you to the recordings of the investigating diary in the police investigation docket, which points out that there was clear instruction that information be sought from the commission and then transferred into the docket. I'm not going to take that any further. My lady, then I would submit that the totality of this event, as they unfolded, point clearly that accused number 11 was arrested on the basis of what transpired and evidence that was obtained from him during the course of the proceedings in the State Capture Commission. That being the case, my lady, we submit that such evidence, when one has regard to the provisions of Regulation 8.2, even in its amended form, together with relevant provisions in the Constitution, my lady, Section 35, which guarantees the right to a fair trial, and also Section 39.2, the approach that this honorable court is called upon to adopt in interpreting legislation and to give effect to the Constitution, the constitutionality as well as the Bill of Rights, that your ladyship should find that this evidence cannot stand.
All of it, or what?
My lady, I'm going to submit all of it, yes. My lady, despite the amendment and taking into account the requirements of the right to a fair trial, we've referred to, my lady, to one of the, I'm not going to deal with all of the cases, but I will refer you to the case of Pile, which is in our head, my lady. The citation is 2004, volume 2, SAC.
Just refer me to the page and paragraph in your head, and that will be fine.
As a court, it is in our practice, my lady, yes.
Your practice.
Yes, that is correct. If I may just give a short background to that case, my lady. In Pile, the accused, following a robbery of a substantial amount of money, and in an unfair or rather illegal manner, her telephone was monitored, and subsequent to that, she was induced to make a pointing out, and following that, a substantial amount of money was found hidden in the ceiling of her house. The trial court had convicted her of robbery on the basis that she was an accessory after the fact. But the Supreme Court of Appeal, my lady, found that this type of evidence and the manner in which it was obtained was unfair, and the acceptance thereof would bring into disrepute the general administration of justice. And a conviction and sentence were set aside. My lady, as I've pointed out, in coming to the right conclusion, my lady, your ladyship is not only restricted to the provisions of Regulation 8. We submit that the correct approach is to give a wide meaning, or rather a wide interpretation to that clause, taking into account the constitutional impact, the constitutional era in which we are today. My lady, I'm not going to take this far. My two learned friends have already taken it, unless there's any question on the issue of from your ladyship.
There's just one thing on that last point. If the court had to, well, what this court is being asked to do is to decide on papers and on the allegations made by each party, matters which would ordinarily be brought before trial court. Do you think that any decision that this court makes is going to fetter unduly the discretion of the trial court?
My lady, the relief that is sought in this case, I'm going to address you on the second level. But these are preliminary reliefs, my lady, based on the premise that the court's time and resources should not be used to come out with what will ultimately come out to be useless judgments, if I may to use that. The court's time and resources are precious, my lady. If before the trial starts, then there is some evidence to show that the trial, the evidence that is supposed to be used, or the manner in which the prosecution has been instituted does not comply with statutes, that has to be dealt with there and then. I submit that it would be unfair to any person, the administration of justice as a whole, the judge, the courts, the accused, if only at the time of the trial these issues are canvassed. My lady, trials normally take a very, very long time. In this case, for example, we have 16 accused. You have a team of a number of legal representatives. If the trial starts now, or when the trial starts, it is quite clear that it's going to take a long time. However, if there are issues that can be dealt with at this time, without having to go or to be concluded after a lengthy trial, it is in the interest of justice that they be dealt with now. I'm aware that the courts have held that the criminal trial should not be dealt with on a piecemeal basis. But this is not such a case. This is a case, my lady, where reliance is placed on specific statutes. And the admissibility or otherwise of the evidence. My lady, I now propose to deal with the second issue that is before you of the application, my lady, and that is the non-compliance by the prosecution with the provisions of PRECA, which is contravention, my lady, which is section 27 of PRECA. Now, my lady, the provisions of section 27 of PRECA are very clear, my lady. We do have a number of legislation that deals with criminal proceedings, my lady. The main being the Criminal Procedure Act 51 of 1977. But over and above that, my lady, the legislature has decided to pass an act, which is the Prevention and Combating of Corrupt Activities Act, number 12 of 2004, which I will call CRECA, my lady. Now, section 27 thereof says the following. The institution of a prosecution for an offense referred to in section 17(1), 23(7)(b), or 34(2) must be authorized in writing by the National Director, a Deputy National Director, or Public Prosecutions, National Director of Public Prosecutions, or the Director of Public Prosecutions consent, and very importantly, my lady, and only after the person concerned has been afforded a reasonable opportunity by the investigating or prosecuting authority, as the case may be, to explain whether personally or through a legal representative, in the case of section 17(1), how he or she acquired the private interest consent. Now, my lady, one has regard to this provision, and if I were to break it down, there are 4 requirements that must be satisfied before an accused person can be charged for contravention of CRECA. And if I may do that, my lady, by way of summary, firstly, there must be authority, or rather authorization. That is the first requirement. The second would be that authorization or authority must be in writing. Thirdly, my lady, it must be given by either a national director, a deputy national director of public prosecutions, or director of public prosecutions consent. Really? Now, in the first place, this authorization should only be given after an accused person has been given an opportunity to give an explanation. Now, the section is very, very important, and there is a reason why the legislature decided to have this piece of legislation in the statute books. The use of the weight, my lady, must only after we submit, my lady, are clearly peremptory. Peremptory weights in any statute are always expressed, my lady, by use of weights such as must, shall, no person, whatever. But the nature and the usage of the weights in this statute clearly demonstrate that the terms are peremptory. Now, what does that mean? Peremptory terms, my lady, in a statute mean that the statute has to be complied with, and that non-compliance therewith renders such action void. Peremptory terms, my lady, are to be distinguished for what we call regulatory terms, which give a discretion to a functionary, such as the use of the word may. Now, we submit that in this case, we have a clear statute of peremptory terms, which must be adhere to. In this case, my lady, it is common cause and the state concedes that there hasn't been compliance with the provisions of Section 27 of PREG. As I've pointed out, my lady, it's common cause that the accused number 11 was arrested on the 1st of August, sorry, on the 1st of October. Of 2020, my lady. At that time, he had not been given any opportunity whatsoever to explain. At that time, my lady, there was no written authority by either of the relevant officials to which I have referred to in the section. Now, the authority, my lady, was obtained only on the 3rd of November. That is almost a month after accused number 11 was arrested. My lady, and still, as at that date, he had not been given any opportunity to give any explanation as required by Section 27 of the Act. This omission, my lady, by the state is not a bona fide oversight by the respondent of an existing legislation. It is not an honest omission. It is a deliberate act. And that the respondent states it clearly, my lady, in their answering affidavit. Their reasoning being that if they had complied with the Act, and this is the explanation, if they had complied with the Act and given warning or an opportunity to accuse number 11, the accused number 11 would have left the country. Already, this is to be found in paragraph 35 of the state's answering affidavit. And it reads as follows. Had reasonable notice been given to Zulu of an intended prosecution based on all the evidence against him, he may have fled the country, made multiple approaches to the courts to evade or delay prosecution, or otherwise have interfered with the investigation. This is the explanation of the state. They are aware of the provisions of the Act, and they decide not to comply with the provisions of the Act. They criticize the Act. They don't like the Act. They don't want to give effect to the intention of the legislature. For the reasons that they give here, we submit, my lady, that these are not acceptable reasons. And in this regard, my lady, that this conduct be taken into account when a decision, when your ladyship exercises your discretion and make a decision in this regard. My lady, I'm going to refer you to two cases, and unfortunately I see now that they did not appear to in our heads of argument. But both of them, my lady, are to the effect that where a statute uses the words shall, must, then those terms are peremptory and must be complied with. Now, compliance, my lady, here, in such a case, is a prerequisite. There has to be compliance. And I must point out, my lady, immediately that there has been issues of degree, whether there has to be absolute compliance or substantial compliance or whatever, but that is not the issue before court. What is before court, my lady, is that there is absolutely no compliance at all, and this non-compliance in this case is intentional. My lady, the cases that I rely on this in this regard is Feinberg versus Peter Maritzburg Liquor Licensing Board. The citation is 1953, volume 4.
1953.
1953, my lady. Volume 4, SA 415 AD. And this is to be found at page 419 to 420. The second one is Monster versus Monroe and another, 1965, volume 1, SA 193. It's also the decision of the appellate division as it was there at page 201. 201, yes.
You say it's 1965 for
That's
volume 1.
correct, lady. But lady, this principle is still the same even today. The basic principles of interpretation of statutes in this regard, my lady, draws a clear distinction between peremptory and regulatory provisions in a statute. But lady, I will submit that in this case, the provisions are peremptory. And if one has regard to the indictment, my lady, the crux of the charges against accused number 11 revolve around contravention of crack. There are also alternative charges, my lady, and the alternative charges also revolve around contravention of certain provisions of crack. We submit, my lady, that in this regard, where the statute is very clear and where the state admits that it didn't comply with the act, accused number 11 is entitled at this stage to bring this application and seek the relief without having to go through a lengthy trial under circumstances where the charges are not properly before court. But we submit that the 11th applicant, so the 11th accused, the applicant at this stage has made a proper case, justifying the relief sought. I'm trying to stick to the time limits agreed upon by lead. I can only hope I didn't exceed them.
You're fine, you're still doing well.
As a court pleases, my lady, unless there's anything that my lady wants to hear from me.
Thank you, Mr. Mark.
As a court.
Thank you. Let's
as the court pleases.
So, my lady, the starting point in any application is to look at the founding affidavit. And you see, my lady, it's a notice of motion. Page 3, he says what he wants is the offences for which the applicant has been charged as accused number 11, B, and is hereby. I'm looking at page 3 of the notice of motion, prayer 1. So he says the offences for which the applicant has been charged is accused number 11, B, and is hereby squashed. Alternatively, applicant is granted stay of proceedings. Alternatively, the matter of the state versus Mokesi and others of which the applicant is accused is struck off the roll. So immediately one asks, what are you charged with? If you go to the charge sheet, it counts 11, 12, and 13. Count, that's what he's charged with. Count 11, it says in that during the period November 2013 to December 2015 at or near Pretoria, in the district of Pretoria and Bloemfontein, carries on, you directly and unlawfully, corruptly accepted, agreed to, offered a gratification, namely 600,000, and then that's count 11 only against 11. That's my learned friend's client. Then there's an alternative contravention of section 4 of PRECA, which is also corruption, illegal, dishonest, unauthorized. And then there's count 12, corruption. That's not against him. So then there is so that's really it. It says you received 600,000, and then there's another one, you received $1 million. So it's charged with fraud, corruption, and then there's an alternatively third count where it says you didn't comply with PRECA, where you didn't report the matter. And I'll deal with that more fully. So that's what he uses. He says you receive 1.6 million rand, corrupt payments. Now, don't complain, you're a big man. Says the state, you are happy to take this corrupt monies. That's what we have to prove. Now you can't complain that it's going to be a long trial. So you get an application and you find his founding affidavit starting at page 5. It says to you nothing in page 6, 5 and 6, nothing. It's just the heading. 7 is 7 up to 7 up to 14. He just repeats what's he's charged with. 15 onwards, my lady, he refers to the regulations. You got the wrong regulation in paragraph 17. Then, I'm sorry this is tedious, but I have to take you through. 18 and 19, he says to you questions were put. Doesn't say to you, I told them I got these payments and what the reason was. And then he deals with nothing else, my lady. It ends up, your ladyship can read it at your leisure, and I'm sure your ladyship already had regard to it. There is no meat in this application. There is absolutely no facts put before the court. I'm an accused, I'm a big player in the country, I received 1.6 million rand, I got an explanation, accept my explanation, don't charge me. Well, that's the end of the criminal justice system. What kind of application are we dealing with? Squash everything. Why? Because I can afford to go to court. I can afford to burden this court with an interlocutory application, which are issues he should take the magistrate in his conference and deal with. Because you'll have regard to our answer. We deal fully with this, my lady. You'll find our answer, my lady. Page 51, paragraph 58. It's long. Starts off, my lady, we said that the AG report, AG was complaining, you're already paying 139. After I report, you paid another 139 million. there's a full report, Your Ladyship will find, the investigation against Mr. Zulu. It came out that there was a cost to company schedule, and the cost to company schedule that we found, when I say we, the state found it, subpoenaed the banks, got the evidence. Man received 1.6 million rand official in the full-time employment of national government, of national government in the housing development. There's nothing, my lady, in the founding paper that justifies any of the relief. So, on what conceivable basis does he come to Your Ladyship? And all he said to Your Ladyship, nothing in the founding papers. You know, this is going to be a long trial, and I don't want to go through the discomfort of a long trial because it's costly. Now, if that's an explanation, with great respect, there's the end of rule of law. The state believes you got corrupt payments, you charge, you go before the court, you want to short circuit the whole thing, ask the state to deal, manage it, as my learned friend Mr. Hoder says, manage it in the pre-trial conference, say to the judge, I will give the evidence on what basis it was paid to me, and if a reasonably possibly true version is found, that might be the end of the matter. But if he wants to go through the whole rigmarole to explain how this transaction came about, how he's the beneficiary of corrupt payments, which he denies, then he must go to a trial. So there's nothing, with great respect, in the notice of motion. He doesn't even ask in the notice of motion for any relief based on PRECA. He doesn't. That's from the bar. But let's deal with PRECA. So Your Ladyship will see that the counts that he's charged with is you received 600,000, you received the million rand. The state explains how it got hold of that information. It's count 13. My apologies, I couldn't find it. It's count 13. During 26 May 2015, you received payment of 1 million, which is not legally due.
Where are you reading?
I'm reading now count 13 from the charge sheet.
Oh, count that.
Yeah, 13, I'm sorry. That deals with the million rand. 11 deals with the 600,000. Count 13 deals with the page 94, my lady. Page 94. And I accept that there is an alternative third count based on PRECA, which I'm going to deal with now. But there's no relief paid for apropos PRECA in the notice of motion. So, is my learned friend suggesting that, look, when you have evidence against a person like his client, where we say this was a backhander, you participated, that's in the preamble, in facilitating this irregular transaction contrary to tender law principles, is he saying that you can't join him with other people? Is he saying it's a misjoinder? If he's saying it's a misjoinder, what is his grounds? Well, it's going to be long and expensive. And that's the price you pay if you engage in conduct of this nature, prima facie speaking. So now I want to take you to PRECA, my lady. And there I want to take you to 27, because that argument was very eloquently put, but there's no link between the argument and what he prays for in the notice of motion. So what 27 says, my lady, is that the institution of a prosecution for an offense referred to, etc., my lady, and only after the person concerned has been afforded a reasonable opportunity by the investigating or prosecuting authority, as the case may be, to explain whether personally or to a legal representative, in the case of 34.2, why he or she failed to report in terms of 34.2. And 34.2, my lady, is the following. Duty to report corrupt transactions. Any person who holds a position of authority and who knows or ought reasonably to have known, those words, who ought reasonably to have known, my lady, has received the imprimatur of the Constitutional Court, my lady, in the judgment. If I'll ask your ladyship just to make a note, it's a reported judgment. Savoy and others versus NDPP, 2014, volume 5, SA 317. It's a Constitutional Court judgment, my lady. Basically, they repeat the principles in paragraph 70 and 71 that all these points must be taken before the trial judge, and this particular point should be by way of a special plea. But that particular ought reasonably have to be known is what the court ARCO said is vague. They said there's nothing vague, it's an objective standard. So a person who holds a position of authority and knows or ought reasonably to have known or suspected that any other person has committed an offense, and then it says, my lady, under 2, I'm sorry, under then goes on, my lady, to say that you must give that person an opportunity to be heard. So the argument, my lady, that's read together with 27C. So what we've submitted in our heads of argument, my lady, that my learned friend says, well, it's peremptory, we argues directly, and by reference in our footnote to the end to many judgment, we say a court will interpret a statute sensibly and reasonably, balancing all the rights. What's concerning us, my lady, as the state, if I may just refer myself as the state for purposes of argument, if you call upon, like if you called upon Mr. Zulu to give an explanation under 34.2, when he's charged with fraud and corruption, then do you impede his right to remain silent? Or can he then say, once I've given you that explanation, you've tainted the whole process? That's the concern the state has. Now, my lady, an attorney or any other person in authority who receives a payment and is suspect that there's something wrong about that payment, what you want to avoid for that particular single transaction, you want to avoid the police rocking up and arresting the attorney or person in authority, because it's a single transaction. Then they say, now look here, Kasim, you receive 100 million rand in your account, we think it's money laundering, you should have reported. Then I'm given that opportunity to give an explanation, and if my explanation is not satisfactory, you charge me. But can you, my lady, in the context of Mr. Zulu, charged with serious fraud, corruption, if he's found guilty, he ought to go to jail for a long time. Do you taint that process? Do you prejudice that process by inviting him to give an answer under 34.2? We say a sensible approach, a reasonable approach, as Ndumeni says, and then amplified between in the Bato case after that by Mr. Justice Wallace sitting in the SCA. We say a reasonable, sensible approach is you do it when there's a single charge. Of course, I accept, my lady, on a practical level, it's not the end of the matter, because it's an alternative third count. If the trial court finds against us, we may drop that count. It's neither here nor there. But we must be given that opportunity to ventilate that dispute before the judge, steeped in this whole matter, so he can see how it came about, and he can give what Mr. Justice Harmse says, quoting Delmas Milling, context is everything. So, to abbreviate my argument, there's nothing in the founding affidavit that justifies any of the relief which our learned friend seeks. He does not make out a case why this court, sitting as a court not dealing with the trial, should simply squash all charges. When there's a prima facie case, we say that we got bank statements that show you receive 1.6 million. And when you look at the innocuous answers of the people who paid to you, well, you've got a long way to convince a reasonable presiding officer that that's an acceptable explanation, but that's a fight for another day. So we say there's nothing justifying what you seek for in the notice of motion. And we ask that the application be dismissed with possible delay. My lady, the Pillay case is analyzed fully where we deal with Ferreira versus Levine, because your ladyship will remember they canvassed all the Canadian cases, and then in Pillay they found that by breaching her rights to privacy and finding the money in the ceiling, there was nothing wrong with that. But they found that when they misled her in thinking that they're not going to charge her, well, they said that brings, undermines administration of justice. And it was on that ground that they set it aside, my lady. The judgment my learned friend quoted in saying is peremptory. That's the end of the matter, my lady. I haven't had an opportunity of studying those cases, but as your ladyship knows, any statutory provision can be read as peremptory or can be read as directory. Directory, that's what we direct you to do, but it doesn't nullify the provision. Peremptory would nullify the conduct. As the court is. Lady, can I just have a look? We found that judgment. If you just give me a minute, the one that my learned friend referred to.
Which one are you talking about? The 1956?
Peter Marisburg liquor licensing and Mostert in Monroe. All right, so what they say, my lady, is the following. That's a proposition I put to you. I advanced before this. The applicant submits that the words must and shall generally indicate an imperative, mandatory, obligatory, or peremptory intention of the legislature. It referred to a number of decisions of the courts, among others, Feinberg versus Peter Marisburg Liquor Licensing Board, which my learned friend referred to, 1953, Volume 4, SA 41580 at 419 to 420, and Mostert versus Monroe and another, 1965, 1 SA 19380 at 201. The effect of these decisions and dozens of others is the same vein, is that the word shall or must, when used in the statute, is to be construed as peremptory and directly, unless there are other circumstances which negate this construction. Well, I'm submitting there are other circumstances which negates this construction because of your other fundamental rights in 35(3). You cannot compromise your right to remain silent. So I said where there is multiple counts, including non-reporting, those are sufficient circumstances which negates the peremptory. And it's more directory means one that you're directed to do so, but it doesn't render the conduct void. That's it to report.
Thank you, Mr. Kiasi. Mr. Markana, any reply?
As a court, this is my lady, very briefly, the submissions by the respondent, my lady, clearly do not address the crux of the issue that is before you. The respondent, my lady, is saying some circumstances where the act cannot be complied with, and he's trying to give an explanation for that. But my lady, the principle of legality is very clear. Anything done contrary to a provision or statutory provision cannot stand. The PRECA specifically requires that there be an explanation. This explanation, whether there was a duty to report or not, whether there was payment or not, PRECA says you should give him an opportunity before you charge. That's the law. That's the principle of legality.
Well, if I understand that argument then, all the other counts, seeing as the charge in terms of PRECA is the second or third alternative, what you're saying then is that should be dropped at this stage. But you're obviously not attacking fraud and corruption charges.
To the extent, the charges as they stand, my lady, all are centered around PRECA because it's charged with other people. And as I understand the indictment, they are all centered around crack. We are saying to the extent of all those that are related to crack, if the state is not entitled to bring to prosecute him on those charges unless they comply with the provisions of
But
Section
with fraud
27.
and corruption, it's not based on the non-compliance of Section
If it's corruption
27.
at common law, yes, my lady, it does not fall under crack.
Because I'm trying to put together your argument and see how it relates to the fraud and corruption charges. Because the tenor of your argument
Yes.
at this point suggests that this court should quash the charge relating to the non-compliance with PRECA.
That is correct, my lady. My lady, we submit therefore that clearly the state did not comply, and for this the relief sought be granted, my lady, with costs, including costs consequent upon the employment of 2 counsel as a proposition.
Okay, thank you. Mr. Hertz, I don't know if you want to start with your application now or do it in the morning, because it looks like we may have to come back tomorrow for those who are not here today. We might have thought that tomorrow is the date set down for the pre-trial meeting.
I'm in the
It's up
ladies'
to you. If you want to,
available.
it's fine. You can go ahead if you'd like.
Thank you. Lady, as I start with the others, I'm not going to repeat.
Just give me one moment.
I'm not going to repeat my learned friend argument.
Just give me one moment, Mr. Woods. I just need to get this file out of the way and the other one relevant to your current argument before me. Yes, thank you.
Lady, with a sense of relief, I need to report that we're going to be here in any event tomorrow, and it's been a long, long day, so perhaps it would be an opportune time to take the adjournment and commence with this tomorrow morning. I am ready to argue, my lady, but we are going to be here, and it's late in the day. We started.
Mr. Kessel,
No, my lady, I think we should do it tomorrow. It's been a long day.
I know all of you look very tired. Mr. Woods
Listening,
looks
listening.
incredibly tired.
Can't bear the thought your ladyship's going to listen to my voice over and over.
All right then. Let's do that rather. Let's roll the matter until tomorrow to hear the 4th application in respect of accused number 13.
My
And I
lady, with
believe-
your leave, my lady, tomorrow could you start possibly at 10 o'clock or
At 10 o'clock.
Yeah, well, what do you prefer, lunch?
That's fine.
Perfect with me.
Yes, if that
Thank
suits you better. You will keep my secretary informed if the accused who have not been dealt with today do appear tomorrow. I can't remember, was it accused
It was
6?
number 6, my lady. So corporate entity represented
By somebody else, and also the representative of number 5. But I understand Mr. Jagannath was going to send a medical certificate in respect of the representative of accused number 5.
I will clarify for the morning.
Because then we have to obviously deal with him in the pre-trial before we carry on tomorrow. Thank you. Court will take the adjournment.
Are you okay to take in case all the ones we're done with away? We'll just leave Magashule.
I think if you don't mind, just to get those people in and going is going to be a problem. I'll bring it with me tomorrow morning.
Do we see you guys tomorrow morning? Or not?
Let's take it back.
Okay, just let us know if you must meet you at the
We're not right there, mate.
Yeah, it's fine, but what is about
Can I do something? Oh, you're right.
Yes, busy for now, we must not take it now. When we volunteer to someone.
Ke re wena o e bona jwang ke bona e re tlotsa mo re customer ke bona gore a ke re no ke tsara le tsone go na le ditsi tse Why are we in time?
Are you guys doing? Oh.
It's a nice.